Oh, oh. There was patient being carried along. Yeah, it's actually. All rise. All persons having business before the Honorable Associate Judges, they're residing over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please be seated and come to order.
Morning, everyone. Welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's calendar. The first of the cases is being done in a hybrid manner, and that case is MARICCO Knight versus United States, number 18 CF 514, consolidated appeal, Dominique Williams versus United States, 18 CF 544, and Dominique Williams versus United States, number 22 CO 27. Have counsel for the defense decided who's going to speak first?
Yeah, I'm happy to.
We have not, sir.
Feel free to proceed. Please stand up and identify yourself for the record, and then we can proceed.
Good morning, Your Honors. Brendan Kearney for appellant Dominique Williams. May it please the court, I'm here with my co-counsel, Keyshawn Henderson. I would like to reserve 4 minutes for rebuttal. These consolidated appeals are about securing constitutional fair process for Mr. Williams. Facing the most serious charges in our criminal justice system with a GED and without an adult criminal record, Mr. Williams was denied his Sixth Amendment rights twice over. First, with respect to the direct appeal, the trial court did not protect his confrontation clause rights, allowing his co-defendant to inculpate him via a police officer's statement to the jury. Second, with respect to the collateral appeal, Mr. Williams received ineffective assistance of counsel in the plea bargaining process, leading him to take his chances at trial. I'll start by addressing the confrontation clause issue, which also implicates Rule 14. First, the statement tying Mr. Williams to the, quote, shooting in Southeast was testimonial. It unfairly prejudiced
I guess
Mr.
before you
Williams.
get to the merits of it, your opponent argues that that issue really wasn't preserved because during the oral discussion of this issue, counsel for your client was asked whether there were testimonial statements and said no. So I thought it might be good first to focus on the question of whether that's an impediment to your argument here.
Yes, Your Honor. Appreciate the government bringing up that issue. I believe that the court should not find waiver here. First, in Zerbst and since Zerbst, the Supreme Court has stated that courts should indulge in every reasonable presumption against waiver of fundamental constitutional rights. Here, Mr. Irving, trial counsel, filed a pretrial written motion flagging the Bruton and Rule 14 issues, which was—
But not with respect to the specific statement, right?
Right.
Or
Importantly,
any statements identified in the motion. Is that right?
that's right. I would submit at that point, Mr. Irving did not know which statements the government was going to introduce. So in its response, the government did identify the statements and addressed the Bruton law, further apprising the court of the issue, which is what's required under this court's holding in Page.
Right. Can I ask you about your reliance on cases like Zerbst, and you're using the word waiver, and the Supreme Court sometimes has drawn distinctions, and this court has as well, sometimes though not consistently, between ideas of waiver, like conscious abandonment of a right, and forfeiture, so failure to preserve a right, which can lead to more stringent standards of review on appeal. But are you focused right now only on waiver and not so much focused on forfeiture, and you plan to get to forfeiture later, or are you kind of grouping those thoughts together?
I was addressing waiver just now, the intentional. I'm arguing that Mr. Irving did not intentionally relinquish a known right during that hearing.
And I mean, through counsel, he's kind of specifically asked other testimonial statements, answer no. So it seems, again, through counsel, he didn't speak, of course, but through counsel, it seems like his lawyer seems to have very specifically indicated that there was no claim there.
I would submit that the colloquy before that question and response was not entirely clear. So we're on the transcript on page 5 from that day, the pretrial readiness hearing. And it seems the court has made up its mind. It refers to a bunch of statements and it says most of which were not testimonial, right? Speaking to the government. And I think the ones that theoretically are, that could be testimonial, you're not seeking to introduce at this point. The government identifies a set of statements, a different night statement to a different detective, and says those we are conceding are testimonial and therefore under Bruton could come in a joint trial. That is either a mistake but that's what the transcript says. Then the trial court turns to Mr. Irving, and I think this is what you're asking about, and asks, are you claiming, Mr. Irving, that there are other statements where any of these others, I think any of these other statements are testimonial? Mr. Irving says court's indulgence, he pauses. We don't know how long he paused, what he's thinking there, but that's what I would submit at this point, that at that point, his no was not intentionally relinquishing a known right, because at that point, he did not know the full substance or context of that statement.
Well, was this specific statement, shooting in Southeast, was that specifically quoted in the government's filing as opposed to just a blanket reference to the detective's testimony, anticipated testimony?
In the government's opposition, it's a one-sentence summary, and it says that it doesn't quote the statement, but it says that Mr. Knight said something about a shooting in Southeast. But Mr. Irving at that point did not know the full context. That would only come later when Agent Robinson testified to the full context of his interaction, how he went to the apartment of Mr. Knight, they cleared it, they found that Mr. Williams was not there.
But certainly he would know the crux of the argument that you are making now, which is that this was a statement by a charged and co-defendant that would implicate or inculpate your client. Right? I mean, isn't that all he needs to know to make the argument at that point? That it's testimonial, at least?
Yes, and I think what I'm saying is between the confusion about which statement he was being asked and his written motion where he brought up Bruton and was making the Bruton argument about the statements, he could have, I agree, he could have said more at that point, but he rests on his motion. And
is your point that it's possible the defense attorney here didn't realize that he was communicating to the judge that I don't need a ruling from you on whether these are testimonial because I'm not contending that they are, and maybe you just got confused and didn't understand what he was doing? Because if that's the theory, then it is a little puzzling why. I mean, if, as I understand it, the trial court relying on that statement then doesn't say, okay, well, here's my rulings about what is or isn't testimonial. I mean, there's no ruling from the trial court either, presumably because the trial court interpreted this as that's not part of my homework, that I'm not being asked to decide that question.
Right. So, I mean, I would say that in the government's motion brief, the government said this: the purpose of the task force members' questioning was not to develop a substitute for in-court testimony, rather it was to find a fugitive. And that's what the trial court had, and that's what Mr. Irving had with the summary of the statement. But this is what Agent Robinson testified during the mid-trial hearing on Mr. Knight's motion to suppress, when the government asked him about the questioning of Mr. Knight. I asked him on a general witness level, did he know why we were looking for Mr. Williams? And then before the jury, minutes later, Agent Robinson characterized what happened after they led Mr. Knight back to his bedroom to get dressed in this way. Then we started to just ask him some very general questions about the investigation. And so, but none of that was before the court at that motion hearing in January on the motion to sever. The court didn't have that full context, that testimonial context, and Mr. Irving did not know that full context.
And when that context was provided, did Mr. Irving say to the trial court, you know, I know there was a pretrial ruling about this, but nobody really knew all the details, and now we know some things that make clear that whatever I may have said or whatever was going on at the pretrial hearing, this really does seem to be testimonial, and so you need to address that matter.
Mr. Irving did not do that at the mid-trial hearing on Mr. Knight's motion to suppress. He did not do that.
Or during the trial when the evidence came out.
Or during the trial, but although at that point, right, we're mid-trial, the possibility of a severance is unlikely at that point, and he also wouldn't want to draw more attention to the statement than the prosecutor already did and would in the closing statement.
Doesn't that affect a forfeiture, even if we don't think there was initially a waiver?
Sorry, could you?
Doesn't the failure to object suggest that there was a forfeiture, even if we don't think that there was a waiver?
I would submit that the original written motion that put the court on notice about the issue, that the government then responded to with the statements and with further argument, that put the court on notice about the issue that Mr. Irving was making on behalf of Mr. Williams.
Perhaps it did, but I guess the difficulty is it seems a little hard from this perspective to fault the trial court for not ruling on that. Assuming there was notice, yes, there's an issue kicking around here in general terms, I would decide it. But then when a defense attorney specifically says, I'm not contesting, that's testimonial, and then the issue is never raised again, it's a little hard to fault the trial court for not having taken the prior, whatever you think the scope of the initial motion was, as something that was still left to be done. And we have a line of cases that talk about settings where a party will file a motion clearly requesting a ruling from the trial court on something, and then never secure a ruling on it, just sort of falls between the cracks. And we generally treat that as a forfeiture and require a heightened showing for relief on appeal. In this case, seems even if it wasn't properly put in sort of a invited error waiver kind of framework, seems like it might fit in that line of thought.
Your Honor, if we want to talk about the plain error, is that what you're asking for? Sure. So I talked about why it's testimonial and why it was error to allow that statement to come before the jury. You know, is a statement about a past event for potential use in a future criminal proceeding. The emergency had passed. You know, the purpose, if it changed, was from both perspective of the questioning officer and from the perspective of Mr. Knight, was about securing testimony, and it clearly implicated Mr. Williams. And so to allow.
And can you help me on the last piece of it? The exact wording of the statement, well, I don't want to say exact because I'm about to paraphrase it, so it's not a good lead into what I was going to say, but it's roughly, I heard a rumor about a shooting in Southeast.
That's right. So Mr. Agent Robinson says, you know, earlier in the conversation, we have a felony arrest warrant for Mr. Williams. You know, do you know why we're here? And right, Mr. Knight says, you know, I don't know, but I heard something about a shooting in Southeast. And of course, he was arrested for for a shooting in Southeast. You know, on the night of the shooting, he's the co-defendant. Mr. Williams was living with him. They're good friends. And so that was the statement that he made.
Well, that seems somewhat, I mean, your argument would be stronger, for example, if he'd said, yeah, he shot somebody in Southeast. Obviously, that would be like a direct accusation that your client had done something. To say, you know, I heard something about a shooting in Southeast seems indirect, inconclusive, rather than kind of directly inculpatory as sort of the brutal, you know, the most prototypical brutal kind of statements tend to be.
I would point the court to the government's closing argument in the trial. When Agent Robinson, and this is what the prosecutor said, when Agent Robinson asked Defendant Knight what he thinks this is about, what does he say? It was kind of a moment in the trial. He says, I heard about a shooting in Southeast. Why on earth would Defendant Knight say that unless he knew precisely what Defendant Williams had done? And how would he know precisely what Defendant Williams had done? Because he was in the car when he did it. That's the only explanation for him to say that. So that's what the prosecutor left the jury with.
I mean, that's a fair point. I have a couple questions about it. One is, did that elicit an objection and a request for some kind of curative response?
It did not. But the error, and that's the prejudice, and that affected Mr. Williams' substantial rights at this trial, because we have, as I mentioned, you have the co-defendant speaking about a shooting in Southeast in this testimonial context. You know, and with the full context here, implicating Mr. Williams in the shooting that the jury is.
I mean, that argument by the prosecutor, which I agree is problematic, seems less about the wording of the statement and more, we know why he, you know, it's more an argument that, in fact, Mr. Knight knows what's going on because Mr. Knight was actually there. So it's kind of less about the statement itself and more about, we want you to infer, jury, that Mr. Knight knew what was going on, and, you know, relative to Mr. Knight's charges, because Mr. Knight was actually there. Right. I agree that it was about, that statement was also about Mr. Knight, but because it was a joint trial and all the jury had heard about the evidence against Mr. Williams, that statement also reflected on Mr. Williams, and that's exactly why the trial. I agree, it does. I was, I guess, trying to make a slightly different point, which is, it seems to, the main point of it seems to be more, you know, Mr. Knight knows Mr. Williams committed the shooting, because he was there. It was, you know, but anyway, it's somewhat unhelpful to your argument that the defense attorney didn't then say, objection, this is really an improper use of this. And remember, I was arguing this shouldn't have been coming in at all. And now all of a sudden it's being used to directly implicate my client. That seems like another possible forfeiture.
With that, can I turn to the collateral appeal? Just briefly. So the trial counsel did not adequately communicate with Mr. Williams or with the government about a plea in this case.
But you would agree that no formal plea offer was ever extended here, right?
That's correct, Your Honor. Again, no formal plea offer was extended because because the trial counsel did not communicate with his client about the possibility and the possible strategic need to seek a plea.
But do you disagree with the factual finding by the trial court that your client told his counsel early on in the process that he was not interested in pursuing a plea?
I don't dispute that factual finding. I would just say that Mr. Williams said that he did not want to plea, right after the arraignment, beginning of the case. Then there were a year and a half passed where more evidence came in, lots of developments in the case, and there was very little discussion of plea after that initial discussion. There was the hearing in July of 2017 where the government mentioned that there had been very cursory plea discussions with.
But have we ever said it's ineffective assistance for defense counsel to not approach the government affirmatively for a plea when no formal plea offer has been extended and the client has at least initially expressed a lack of interest in pleading?
I would point the court to the decision in Cosio, which the trial court cited and which the government also cited. And in that case, that's about the duty to investigate and what's appropriate in terms of investigation. And this court said it's objectively unreasonable for defense counsel to make an uninformed decision about an important matter without justification for doing so. And so I would suggest that applies here. It's a very important question about whether they're going to plea ahead of trial. At the January 2018 pretrial readiness hearing, the government previously had said only a murder 2 plea would be on the table or possibly be on the table. At that point in January 2018, a few weeks before trial, says it would have to be to some sort of homicide count, which seems to create some ambiguity about what's possible at that point. And the trial court acknowledged that as the parties get closer to a trial, they're more likely to make a deal. Trial court also acknowledged that some reasonable attorneys would have discussed that with their client and then investigated further with the government about the possibility of a plea. And so in Cosio, the court also said strategic choices made after less than complete investigation are reasonable precisely to the extent that reasonable professional judgments support limitations on the investigation and whether the known evidence would lead a reasonable attorney to investigate further. And so there was no reason for any limitations here. All Mr. Irving had to do was speak to his client about what he'd be willing to plead to in terms of a count in years and have a similar discussion with the government about what some sort of homicide count might mean. And so that's what we would suggest.
So it strikes me that in every case where someone goes to trial and is convicted, then we're opening up an argument that the failure to explore a plea or to continue negotiating for a plea is always going to open up ineffective assistance of counsel. So I just don't know how that can be.
I would say that the Supreme Court did not suggest in Lee that a defendant must hypothesize his counsel's advice might be erroneous and state contemporaneously that his plea decision would differ if that were so. Mr. Williams did not have the information during the course of the pretrial period from when he was arraigned in July 2016 to the pretrial readiness hearing in January of 2018. He didn't have the information about what the plea option might be. Mr. Irving had only said at their original meeting that Mr. Williams faced at least 30 years on the counts that he was charged with, when in fact he was facing, if sentenced consecutively, to over 100 years on those counts. And so he didn't have the maximum properly, and he didn't have the minimum either, because there was never any discussion of what a possible plea might be.
Your
for-
focus so far has been on your client's perspective. Another strand of the trial court's thinking was to say, I think paraphrasing something along the lines of, I'm just not convinced that there ever would have been a plea. I don't credit, the trial court didn't credit aspects of your client's testimony about how amenable to a plea he would have been. Now, I agree, it's somewhat inferential what your client's attitude might have been if there had been further discussions. So that's an uncertainty for sure. But the other side of it is the trial court thought, notwithstanding the reference to, it would have to be a homicide, plea to a homicide count. The trial court just thought I don't see any good reason to believe that the United States was going to accept anything other than a plea that I'm pretty confident no matter what happened, your client wouldn't have accepted. That seems to be kind of the upshot of the trial court's reasoning. And I take it you don't contest any of the purely historical factual findings that the trial court made after the hearing.
No, I'm not contesting the facts. I mean, I would just say that from murder to some sort of homicide count, that there's a difference there. And that if that was explored, with Mr. Williams, if Mr. Irving had explored that with Mr. Williams about what that might mean, what some sort of homicide count means.
Understood, but the trial court's thinking on that seems to in part be that in the post-trial motion, it's your client's burden to establish a reasonable probability that if more had been done, an outcome would have been different. And the trial court's, again, paraphrasing the gist of the trial court's analysis on an aspect of that is there is this reference to homicide, but there's a lot of other information in the record that seems to suggest the United States was not going to be lenient at all. And given, and nobody's called the prosecutor, or, so there's been no kind of more direct evidence other than what was going on contemporaneously. And I just don't see enough there, the trial court seemed to say, to find a reasonable probability that there ever would have been some sort of a reduced plea agreement on the United States' side that your client would have been willing to accept. And what's the flaw in that thinking, in your view? Do you think that's a fair characterization of the trial court's ruling?
No, that's fair. I can't say what the government would have offered. We just know that they said some sort of homicide count. We know that as parties get closer to a trial, that there's the possibility, they're talking about the possibility of a plea. And so that possibility was out there if it was explored. Mr. Irving, is a veteran defense attorney. He's handled murders before, he's handling dozens of cases at this point. His client first time through the adult criminal justice system. And it was on him to fully explain to Mr. Williams, what the possibility was here. And Mr. Irving even said during that post-conviction hearing that he knows that he's had clients who have said no at the arraignment stage. And then as the evidence comes in and you get closer to trial, that they're willing to plea. And I think when that wasn't explored with the client and wasn't explored on the government side as well, right, there was no formal plea extended. And that's why we would suggest that the remedy here is a new trial where, with effective counsel, Mr. Williams and the government could discuss the possibility of a plea.
We're well over time unless my colleagues have further questions. We'll give you a couple minutes in rebuttal, and we will hear now from Mr. Laughlin on behalf of Mr. Knight.
Thank you.
Good morning. May it please the court. I am Keith Laughlin representing MARICCO Knight in this case. Well, with the court's permission, I would like to reserve 2 minutes for rebuttal. Mr. Knight's conviction should be reversed for the following reasons. First, the trial court erred in finding Mr. Knight's statements to police were voluntary and therefore not subject to Miranda warnings. Second, the trial court erred in denying Mr. Knight's trial motion to sever his case from Mr. Williams because the allegations against him were so logically and temporally distinct from the proof against Mr. Williams that the cases were essentially unrelated for purposes of joinder. Mr. Knight was prejudiced by the improper admission of his unwarranted statements to bolster an inference that he either had significant knowledge of or participated in Mr. Williams' alleged acts. Third, the record does not reflect evidence that Mr. Knight acted with the specific intent required to sustain either his convictions for accessory after the fact or obstruction of justice. The trial court's findings that Mr. Knight was not subjected to custodial interrogation by the police were clearly erroneous for two reasons. First, the police had probable cause to obtain an arrest warrant for Mr. Williams and to search for him at Mr. Knight's residence. The logical corollary to this probable cause is that the police did and reasonably should have suspected anyone found at Mr. Knight's location to have knowledge of Mr. Knight's whereabouts or be actually actively harboring him.
Counsel, can I, sorry to interrupt you. So you started by saying that the statements by your client during that interrogation were not voluntary. I didn't understand that to be your argument on appeal, as opposed to the fact or the claim that your client was in custody and therefore Miranda warnings were required. My understanding is that we treat the voluntariness of statements as a separate question from whether Miranda warnings were required based on custodial interrogation. So is it your position that both it was custodial interrogation and Miranda warnings were required and the statements were coerced?
Under these circumstances, yes. I think that the nature of the coercion flows from the lack of voluntariness in this case. I mean, as Your Honor alludes, I mean, custodial interrogation typically applies to circumstances where there is a serious danger of coercion. This court has, refined that test to encompass circumstances where there's a show of authority or some message conveyed where a suspect would not reasonably think he or she was free to terminate the questioning and leave, or that their freedom was restrained to the degree associated with a formal arrest. In this case, Mr. Knight was confronted on each of these occasions in his home by armed officers who had the color of actual authority via an arrest warrant to be present and the apparent authority to engage in the interrogation of Mr. Knight regarding Mr. Williams' whereabouts for purposes of the analysis typically engaged in by the Supreme Court regarding what is or isn't a voluntary statement or what is or isn't a coerced statement. These circumstances satisfy those standards in that the circumstances were both custodial, in that the police had every right via the warrant to be in Mr. Knight's apartment. He had no reason to believe that he could tell the police under those circumstances to go and by extension terminate the interrogation. In the December 2015 occasion, he was subjected to interrogation about Mr. Williams' whereabouts for approximately 30 minutes while surrounded by armed agents. Similarly, in February.
Counsel, can I ask you a factual question? It was not so clear to me from the transcript, and I'm wondering whether it is clear to you exactly how long through what was testified to would it be like a 30-minute incident, the statements at issue. And the statement that seems most significant is again, the same statement we were discussing earlier about having heard rumors about a shooting in Southeast. Is there any indication that you're aware of in the record about whether that happened like very quickly after they returned to the bedroom and Mr. Knight put clothes on, or whether that was much later in the discussion?
My understanding of the record is that it was at some point proximate to when Mr. Knight was allowed to return to his bedroom and begin putting on clothes. And I can further review the record, but that was my understanding of the transcript.
Can I ask you, I mean, you talked a little bit about the circumstances that lead you to believe that your client was in custody for Miranda purposes, and you mentioned very quickly the idea of how prejudicial the statements were. And I think it'd be, I know you have other issues you want to touch on, so I think it'd be helpful to me, at least, if you could be concrete about what you think the the prejudicial effect of the statements? Like, which of them did you view prejudicial as prejudicial, and to what extent and in what way in light of the other evidence against your client?
Sure. I think the statements that your honors have specifically touched upon with regards to Mr. Williams' case are the most prejudicial ones, in that they were used explicitly by the government to argue the inference that Mr. Knight was present at the alleged murder and had some knowledge and or greater participation in those acts than were otherwise indicated in the record. The statements were the race gesti of that inference. But for those statements, there's no evidence other than their prior relationship that the government could have possibly relied upon in order to draw the evidentiary conclusions necessary to sustain Mr. Knight's convictions.
So on the question of prejudice, I mean, he had a separate phone call with Robinson, correct? And said a lot of these same statements. And so doesn't that really kind of discount the prejudicial effect, even if we assume this was a custodial interrogation?
Not necessarily. I think that had Mr. Knight been properly warned, he would have been on notice that he had a constitutional right not to give any statements whatsoever to the police under the factual posture of this case. As referenced, the police
Sorry, just to be clear, you're saying if he was Mirandized at the first encounter, then he wouldn't have had the statements on the phone? Because I don't take you to be challenging the statements on the phone.
I'm testing the inferential flow of that. Had he been properly Mirandized in the first place, he would have been on notice that he had a constitutional right not to make any statements. So I think it is somewhat speculative to conclude that he would have made further statements to the police had he known in the first instance that he had a right not to.
I guess I take Judge Alicon's question to be that she had the argument you seem to be making now seems to be different from the one that was in your brief, and also I think not one that was in the trial court, although since the trial court ruled against your Miranda claim, that may be less significant. But the idea that it's sort of the statements on the phone call were the forbidden fruit of an earlier Miranda violation and should have been themselves excluded, and that was kind of further prejudice of what you're arguing was a Miranda violation. I just didn't see that argument in your brief in this court.
It was not in the brief, but it was just, I thought, a logical outgrowth of Judge Alicon's question.
But it seems like it cuts the other way, because if we're trying to determine whether there was prejudice and you have not preserved any objection to the statements on the phone, it seems like that really just kind of takes the wind out of the sails of any prejudicial effect, except I guess the statement about something about a shooting in Southeast, because everything else on the phone about having not seen Williams is exactly what he said in person.
I respectfully submit that the statements that were made under these circumstances were in fact fruits of the poisonous tree. I mean, there is a question of what Mr. Knight's state of mind would have been towards any statements towards the police had he been properly Mirandized in the first instances, whether or not he would have sought counsel, whether or not he would have availed himself of his rights to remain silent and not inculpate himself, arguably, in Mr. Williams' acts. The issues, I believe, were adequately preserved in the trial motion, as they, I think, encompassed the entirety of the Miranda issues that flowed.
Well, so let's say we suppress everything on all three meetings, calls. I mean, we still have the fact that your client was caught fleeing from the car. And so that alone established that he knew about the shooting in Southeast, right? So what's the harm from the introduction of the statement?
I think that data point only goes to that he was in the proximity of the shooting in Southeast. I don't think it goes to his knowledge or any participation in the alleged acts. I think on this record,
For purposes of the charges against your client, it wasn't really necessary for there to be any proof of his participation in the act as opposed to his awareness of the incident and the fact that the police were seeking to apprehend another person involved in the incident.
Well, again, I think it goes that data point goes to where he was relative to another offense that he may or may not have knowledge of or participated in on that evening. I think that the statements go to putting him more concretely.
Wasn't there also the evidence from a girlfriend or former girlfriend about a statement that the police were trying to pin a body on Mr. Williams, the same body that they were trying to pin on Mr. Knight?
Yes, and that goes to questions of the specific intent that Mr. Knight lacked in this case. But yes, there were other statements from other individuals who actually did allow Mr. Williams to stay with her during the relevant time period.
So I'm sorry to be dragging you back to the phone call, but clearly that's where I'm stuck. I thought we didn't, or that the Supreme Court had rejected the fruit of the poisonous tree doctrine in the Miranda context. So I guess I'm just wondering how in a non-objected to phone call can we get to some question of that is either fruit of poisonous tree or that kind of, contributes to a prejudice analysis rather than kind of undercuts it?
I think that the proper reading of the United States v. Batain, which is the Supreme Court case that the government principally relies upon, only extends to statements that were voluntary and that led to tangible or physical evidence being seized. I think that this case is distinct in that first, the statements on these facts were not voluntary. And second, that they were in effect, or as guessed by that, attached Mr. Knight to being an accessory or obstructing justice in this case. So I think that there is something of an analytical distinction between Batain and these facts. I think that this case is more analogous to this court's decision in September in Williams v. United States. The citation is 283 Atlantic 3rd, page 101, where seizure of drug paraphernalia, where the convictions were based solely on unwarranted statements, was found to be an invalid conviction. I think in this case, this case is analogous to Williams in that, but for those statements, initially, there's no phone call, there are no statements made during or inferences drawn from the second sweep of Mr. Knight's apartment. And
I think we have your point on that. You're over time. I know you want to save a little time for rebuttal. Did you want to take a quick minute or two to touch on one or the other of the points that you had flagged?
Yes, just briefly, I'll confine this to the illegal sufficiency piece of this. Both accessory after the fact and obstruction of justice are specific intent offenses. The evidence in this case, in this record, is just bereft of any evidence that Mr. Knight took any action to, counsel or coerce Ms. Samuels to allow Mr. Williams to stay with them.
Did you say counsel? You said something in coerce. I didn't hear the first word.
Counsel and coerce.
Oh, I thought he expressly asked her if she could stay.
No, the record is from Ms. Samuels' testimony. This is in the February 26th transcript, that it was her idea to allow Mr. Williams to stay with them on the respective occasions. Although she and Mr. Knight were living together, it was her idea, in that Mr. Knight didn't specifically ask her to allow Mr. Williams to stay with them. I think Your Honor may be thinking of a separate occasion where they had been drinking together, and Mr. Knight asked Ms. Samuels if she would drive.
No, I thought there was a situation where Knight asked Samuels if Williams could stay over because Williams was having an issue with his, I think, baby mother.
Yes, and on that occasion, the conversation was that Mr. Knight informed Ms. Samuels that there was an issue, and Ms. Samuels sua sponte said, hey, he can stay here in the basement. It was nothing more specific than Mr. Knight imparting that information to Ms. Samuels. Nothing along the lines of, hey, can he stay here? It was more in the vein of, hey, my friend is having this problem. And then the testimony is that she said, okay, he can stay here.
Counsel, is it your position that even if it was someone else's idea to harbor him, that your client therefore can't also have participated in that harboring?
Yeah, on these facts, no, I would argue against that conclusion. I think that both the accessory and obstruction statutes require a higher quantum of evidence to establish specific intent other than a mere conversation with a girlfriend who then makes a independent volitional decision to act or to provide some shelter to a third party, in this case, Mr. Williams.
Thank you, counsel. If my colleagues have further questions, we will give you a couple minutes in rebuttal, and we'll hear now from the United States.
Good morning, Your Honors, and may it please the court, Eric Hansford for the United States. The defendants failed to show any reversible error on the various issues that they raised in this direct and collateral appeal. And unless the court would like me to go in another order, I'd be inclined just to take the issues in the order they were presented here this morning. So I'll start with the defendant Williams's Bruton issues. We're making three sets of arguments with respect to those. First is that they were waived, or at the very least not preserved, and therefore subject only to plain error. Second is that on the merits, they're neither testimonial nor the sort of inculpatory statements that would implicate Bruton, especially on plain error. And third is that given the overwhelming evidence of guilt in this case against defendant Williams, and the nebulous nature of the statements here, there wouldn't be prejudice. Just on the waiver point, in terms of what we've discussed this morning, I just wanted to note, after Mr. Irving makes the statement, the trial court asks him, are you arguing any of these are testimonial? And he asks for the court's indulgence, takes a pause and says, no, Your Honor. The court asks a follow-up question, which emphasizes kind of what the relevance of these questions is. The court asks, okay, because if they aren't, then is there any other basis for a severance claim? And then Mr. Irving responds, I have nothing further, Your Honor. So insofar as kind of the prior exchange might have been slightly ambiguous, the court does ask that follow-up question and drive home the point of what the relevance is. And then immediately after that, the court says, okay, the motion for severance is denied. So I think as the court's questions this morning were addressing, this is a situation where the defense was telling the court, we're not asking you to take this position, and indeed we're conceding that they are not testimonial, and therefore there's not a basis for a Bruton claim. Also, just in terms of the preservation on plain error, we just want to note that filing a boilerplate form motion, which is very much what this was. You know, it doesn't discuss the statements. I'm not sure it even uses Mr. Knight's name in the motion. That is not a sufficient way to preserve the issue under Duddles. So I can talk on the merits again, but I think either the waiver issue or the prejudice issue are probably the easiest ways home here. On the Bruton issue, there was overwhelming evidence of guilt against defendant Williams. He makes this very inculpatory statement to the IHOP manager that this is kind of a neutral third party, a witness with no reason to kind of fabricate this. He leaves this accidental voicemail that corroborates the IHOP manager's account, and also that it was defendant Williams who was speaking to the IHOP manager. His DNA, defendant Williams's DNA, is found in the seat that one of the surviving victims describes the shooter being in, the back rear passenger seat. And then also you do have the evidence from the cooperating witness, the person who's in the car, whose evidence is otherwise corroborated. And then you've also got body-worn camera footage that appears to show defendant Williams fleeing from the car after the crash from the seat where victim Burrows describes.
So counsel, the government clearly thought that this statement by Mr. Knight about the shooting in Southeast was highly inculpatory, not just as to Mr. Knight on his 2 counts, but also as to Mr. Williams, right? I mean, you relied on it quite a bit in closing argument. So
I don't think we relied on it quite a bit. I mean, I think the passage that was read was the time when that's referenced, but that is discussing Knight's guilt. In that passage, that's a passage describing how it is that the jury would know Knight was at the shooting, as opposed to trying to use it against defendant Williams.
But its logical structure is the reason that Mr. Knight is guilty is because he knows that Mr. Williams was involved in the shooting. And the way we know that is from this statement, which shows, and the reason he knows what he's saying in the statement is because he was there and he saw Mr. Williams commit the shooting. And it may have been in context at the part of the argument where the prosecutor is explaining to the jury why Mr. Knight is guilty. I think that's right. But its logical structure rests on a pretty clear statement that connecting this statement to the idea that Mr. Knight knows Mr. Williams committed the shooting because he saw him do it. Do you disagree with that? Or
I mean, I think we do disagree in terms of that. It would be the statement itself would be kind of useful evidence against defendant Williams. I think the Bruton cases from the Supreme Court very much emphasize that in trying to assess whether there's a Bruton problem, you're not looking at kind of how the various.
I'm not really making this point as a Bruton point,
sure,
as much as the way the prosecutor used it had as its logical in the logical chain of reasoning was to connect this statement by Mr. Knight to the idea that Mr. Knight knows Mr. Williams committed the shooting because he was there and saw Mr. Williams commit the shooting. So whatever you might think about Bruton and what statements are sufficiently inculpatory to trigger Bruton's protections, I'm just focused more on the way the logical structure of the point the prosecutor was making, which seemed to be taking, again, in a larger context that was focused on Mr. Knight. I agree with that, but still the logical structure of it is this statement is part of. We're going to focus on the statement and say, yeah, the reason Mr. Knight made the statement is because he knows he was there. He saw Mr. Williams commit the shooting. That's a pretty direct, however facially inculpatory it was, that closing argument was a relatively explicit use of it to incriminate Mr. Williams for the purpose of showing Mr. Knight's guilt.
So I mean, I would say that it's not problematic in the way, I mean, Bruton recognizes that a statement that is inculpatory against a co-defendant might end up connecting with other evidence in the case. And it might ultimately, in that kind of full mosaic of evidence, create strengthen the government's evidence against the defendant who's not the testifying witness. And so in Richardson, there's like a conversation that happens in the back of the car where that ultimately the court says it's permissible to introduce the statement about a conversation that happens in the back of the that happens in the car when the defendant is in the back seat, which might kind of inferentially suggest more knowledge of the defendant or might connect with the rest of the evidence. And so what
Again, you're connecting it in a way that I'm on a slightly different vector. So let me just try to explain again. And maybe I'll ask it this way. Do you, leaving aside Bruton and considering just hearsay, for example, do you think it was appropriate in a joint trial for the prosecutor to say, this isn't exactly what the prosecutor said, so this is a hypothetical that is somewhat more explicit than what happened here, certainly more explicit than what happened here. If the prosecutor had said, look, we have the statement from Mr. Knight, and it's Mr. Knight saying, I heard a rumor about a shooting in Southeast, and that's, pretty good evidence against Mr. Knight and the offenses against him. But it also, it is evidence against Mr. Williams, because it shows it's Mr. Knight basically telling the police in veiled terms, I was there, I saw the shooting, I saw Mr. Williams commit the murder. Would that be a legitimate argument to make? Leave aside Bruton or anything else, which is in closing argument, assuming a joint trial would come in permissibly, would that be a permissible use of that statement?
So I mean, I think in general, trying to use Knight's statement against Williams is going to raise issues. And
At a minimum, hearsay issues, you would agree?
Well, I mean, so in terms of hearsay, I mean, the hearsay, it's not hearsay if it's not being used for the fact asserted in the statement. And so here, what he's asserting facially is, I heard something about a shooting in Southeast. That's being used by the government to say, in fact, that's not true. He didn't hear something about a shooting in Southeast. He has knowledge of a shooting in Southeast, and that shooting is the relevant shooting that we're investigating. But facially, the statement doesn't say that, which is relevant both in the Bruton context and in the hearsay context. I'm not saying it's kind of, had there been an objection to this at closing argument, it's entirely possible there would have been some sort of kind of limiting or directing instruction. We're not saying kind of this was a long trial. We're not saying it was necessarily perfect, which is what Bruton says. Inevitably, there are going to be little things that happen that come up at trial. But in terms of the actual objection that's being made on appeal, it is a Bruton objection. It's not an objection to what was happening at closing arguments. And there's no error, certainly no plain error. If there are no other questions on the Bruton issue, in terms of the plea and the ineffectiveness claim, as we laid out in the brief, we think that claim fails for many reasons. I think maybe the easiest way home for the court there is that the defendant, and the trial court credits that the defendant was consistently uninterested in taking a plea, that the defendant was instead insisting on going to trial, saying to his defense attorney that he didn't do it. And so just in terms of the prejudice, the defendant has to show a reasonable probability that he would have taken whatever plea there was going to be, and he can't make that showing. And in fact, the record shows the defense attorney going back to the defendant and confirming this, including after the January 19th trial readiness hearing, the defense attorney has a conversation on January 22nd when he asked the defendant, do you want me to go ahead and get a plea from the government just to see what it is? And the defendant instructs him not to get a plea. And in fact,
counsel, putting aside what Mr. Williams said to his attorney, is it your position that in the normal case, defense counsel's obligation to explore the possibility of a plea with the government only flows in response to any outreach by the government first? I mean, would it be, is it ever ineffective assistance for defense counsel to completely fail to even broach the prospect of a plea with the government in the first instance?
So we are not arguing that the government is the only one who can make a plea or the only one who could broach a plea. I think, no, I don't think we're making that sort of categorical argument that what needs to happen is the defense is waiting for the plea from the government. And I think what in fact happened in this case, which reflects kind of proper effective assistance of counsel, we think, is the defense attorney early on is asking the defendant, are you interested in a plea? Is talking through the strength of the government's evidence, and is having those conversations with the defendant. And the defense attorney here, who's a very experienced defense attorney, explains this is a delicate matter. You have to build trust with your client. And so if you're pushing a plea on the client that the client's not interested in, that could break trust. And so what the record shows is this experienced defense attorney is having those sorts of conversations with his client. So we're certainly not making any sort of categorical argument that you have to always wait for the government to make a plea offer. Also, I think just in terms of the homicide reference that was made during the trial readiness hearing, I think it's important to note that that reference itself is a reference to discussions that have already occurred. So it's not the government saying we would like a homicide plea. It's instead the government saying we had a discussion. We were insisting on a homicide plea, and Mr. Irving said basically that's not going to be possible. So it's representations about discussions that have already happened, and that makes it reasonable for the defense attorney to understand that this is not a suggestion that the government's suddenly open to, voluntary manslaughter or negligent homicide or whatever, that this is instead just putting on the record the discussions that had already happened, where the government was insistent on a second-degree murder plea. If there are no further questions on the Williams issues, I can move to Mr. Knight's issues. So in terms of Miranda, I think, again, the easiest way home here is prejudice. I think it's important to say that in the motion to suppress below, the defense attorney explicitly said he was not seeking to suppress the phone call statements. So that's on, this is the February 21st, 2018 transcript, page 685. The court asked the defense attorney, what statements are you claiming specifically are problematic? Defense attorney says the statements made during the first and second visit to the apartment. The court says not the statements made on the telephone. Defense attorney says, no, I don't think I have a basis for that. The court says, I don't think you do either, but I just want to be sure. So the defense attorney is telling the court this is not something that he is seeking to suppress. And so given that, there are, I think as Judge Ali Khan was saying, numerous very, very similar statements that Mr. Knight is giving. His arguments have very much focused on the December encounter with the police, but he gives very similar statements in the February encounter, where there aren't kind of the pulling out into the hallway and all of the facts of the December encounter that Mr. Knight's has emphasized in his brief. And then there are similar statements in the telephone call. And so there are both very similar statements, and there is already very strong evidence that defendant Knight was in the car at the time of the shooting, including that at the scene of the crash, shortly after the shooting, I think 45-ish minutes after the shooting, at that point, defendant Knight is caught at the scene of the crash, fleeing from the car, fleeing from the front passenger seat. So that provides very, very strong evidence that he was in fact present for the shooting, in addition to the cooperator's testimony, which puts him there.
So that sort of takes you to a sufficiency question. And so my question for you on that is, what is your best evidence of the mens rea for harboring?
So it is not correct that defendant Knight never asked for defendant Williams to stay with him. In fact, or to stay with Miss Samuels. The evidence was that the very first night they had been drinking and defendant Knight asked to drive home defendant Williams, and Miss Samuel says, no, I don't want you using my car. You've been drinking. You can stay the night. But then subsequent to that, defendant Williams repeatedly stays there. And that testimony was that at least on one occasion, when defendant Williams stayed a few nights, defendant Knight goes to Miss Samuels and says, Mr. Williams needs a place to stay. He's having issues with his baby's mother, and asks that he stay there. He's also, defendant Knight is giving defendant Williams, like, letting him borrow his shirt, and Miss Samuels asks, why are you letting him do that? Defendant Knight says, because he's my man. So there is evidence that he is affirmatively aiding, harboring.
So is it your position that knowledge that the individual committed a crime plus harboring is sufficient to establish the intent element? I mean, suppose you have a parent who takes in their child having known that an adult child having known that the child had committed a crime, but of course they're potentially probably doing it largely out of concern for the child's well-being or safety or whatever it is. I mean,
So I think our position is that it would permissibly be a jury question at that point. The jury's properly instructed here that on the intent requirements, that the intent has to be in order to be for obstructing, in order to be interfering with the due administration of
right.
justice.
I mean, of course, it's a jury question, but if you have no evidence, the government has no evidence of any indication that the parent in my hypothetical or Mr. Knight ever said anything like, we're going to keep you out of sight. I know the cops are after you, anything like that, that would be sufficient evidence to establish intent.
Yes, I mean, I think it is common to not have direct evidence of intent or of a mens rea. And in fact, that's a jury instruction that's given in basically every case, that you're rarely going to have direct evidence of the mens rea of the intent, and you're in fact instead going to have to infer it circumstantially. So
can I just to go on the parent example for a minute? Imagine the situation was as follows. Imagine that a child is allegedly involved in a crime, and a parent knows that the child is allegedly involved in the child and the child in the crime, and the police are looking for the child. And the child resides with the parents ordinarily and has been, before. So it's not a change of what the child is doing. And after that, aware that the police are looking for the child, the parents allow the child to continue to reside at the parents' home. And eventually the police come and find the child there and apprehend the child, and then charge the parents with either obstruction or accessory after the fact. And the theory is the parents were aware that the police were looking for the child, and the parents nonetheless, provided accommodations to the child. Would you say that's a jury question? And then let's assume there's no other evidence of the parental intent. Or would you say instead there's no reasonable inference, there's not enough evidence to permit a reasonable jury to infer beyond a reasonable doubt that the parents were trying to obstruct justice? Among other things, in that hypothetical, the parents might reasonably think, we're not hiding the child. This is where the child has lived. The child is continuing to live here. So we're not interfering with the police finding the child. We're not turning our child over, but we're not, what we're doing doesn't operate to hide the child from the police. But in that hypothetical, would you think that it's still a jury question, even though there is that difference, perhaps from an aspect of this case?
So I mean, I think that would be tough for us to argue that it's a jury question in that case. I think that when you don't have affirmative conduct by the person who's doing the aiding and abetting or the obstructing, I mean, potentially that becomes a problem.
Affirmative conduct is a murky concept. Well, I mean, imagine in the hypothetical, the child says to the parents, can I continue staying here? And the parents say, yes. I mean, it's affirmative conduct in a way. So I'm not so sure that the issue, for me, at least as I was thinking of it, was a lack of affirmative conduct. It was more, what can you infer from the provision of support to someone with whom you have a relationship? When is it reasonable without direct evidence for a fact finder to infer that it wasn't just, I'm not trying to interfere with anything. I'm helping out people who I help out, and I'm not trying to help the police. I'm not trying to hurt the police. I'm just doing what I want to do as a friend or as a parent. When is it reasonable to infer that's what's going on? Or put differently, when is it unreasonable to infer that more than that is going on unless there is additional evidence? That's the question.
Sure. So I mean, I think in the very, very bare facts that the court has posited, I think it would be hard for us to argue that's a pure jury question. I think once there's kind of a little bit extra in terms of the facts, if the child doesn't normally live there and is now asking to live there, I think at that point it does get into these classic situations where we can't look inside someone's head, and instead what we have to base the intent on is kind of what the circumstances would
But
suggest.
one could say here that the circumstantial evidence was all pointing toward him having opened his home for legitimate reasons, right? The notion that he was asking his girlfriend because he was having trouble with the baby mama, and then also drinking outside on the patio doesn't suggest a sort of intent to secrete somebody or to harbor somebody. And so, what is the sort of evidence on the other side of the ledger that makes this a reasonable question to go to a jury?
So I think first is the evidence, the warnings given by Agent Robinson, which are not interrogation, wouldn't be implicated by the Miranda issues, that this is a wanted fugitive. This is someone we are looking for. In fact, the police have repeatedly come to Mr. Knight's former residence and looked for this person. And so when Mr. Williams is then staying with Mr. Knight, or Mr. Knight is offering a place for Mr. Williams to stay, that's kind of affirmative evidence that he's helping.
Can I ask you a question about that too? Was it the government's theory at trial, or is it your theory now? And if so, was there evidence to support the theory that in any of the statements that Mr. Knight made in the conversations with the police, the phone conversation and the two in-person conversations, that Mr. Knight lied to the police about his prior contacts with Mr. Williams? I know there was some suggestion that the police had an anonymous tip that Mr. Knight had been staying at Mr. Williams's, but I'm not sure that was, evidence of a kind that a jury could be relying on for the idea that Mr. Knight was lying to the police. But it seems like if there was evidence that Mr. Knight had been lying to the police about prior contacts with Mr. Knight, that would be a good piece of evidence for the United States. And I don't remember you kind of making that argument. So
I mean, I think what the court's referring to was the extent of it, that there was some evidence that he had in fact stayed there earlier between the December and February searches, but it was just like an informant statement. It wasn't. And I think just in terms of the evidence that Mr. Knight was lying, though, there's also his statements to Miss Samuels after Mr. Williams gets arrested, which is when he hears this immediately, he says an expletive. And then afterwards, he explains to her that they were trying to pin the same body on Mr. Williams that they've been trying to pin on Mr. Knight, and that Mr. Williams was running because nobody wants to be arrested. And so I think all of that is suggestive, or at least would allow a jury to infer that in fact, what was going on here was not how Mr. Williams and Mr. Knight were presenting the situation to Miss Samuels, but in fact, it was just kind of classic harboring that was going on in this case. If there are no further questions, we'd ask this court to affirm.
thank you, counsel. Mr. Kearney, we'll hear now from you. We'll give you a couple minutes in rebuttal.
Thank you, Your Honor. I'd like to make 2 points on the direct appeal and then turn to the collateral appeal. First, with regard to waiver, the government noted the ambiguous exchange at the pretrial readiness hearing, but pointed to trial counsel's subsequent statement that I have nothing further, Your Honor. And I would note there that the trial counsel is resting on his written motion because he doesn't know any more about the statement, as I was saying earlier, only has what the government wrote in the motion. And for the same reason, that's why his motion was boilerplate. He didn't know what the statements would be. And so that's why I would say on waiver, because of the Supreme Court guidance in Zerbst, and the issues that were raised in the written briefing and the way that the government presented the testimony to the court in a critically different way than how Agent Robinson actually questioned Mr. Knight and how he testified to the jury, that there was no waiver. I would next move to the evidence question. There was other evidence, as the government noted, but this statement, as we've discussed here today, tying Mr. Williams to the shooting in Southeast, was powerful testimony from his friend, his former roommate, and co-defendant at the joint trial. And so I would say that you look at the standard under harmless error for a Bruton violation, that would be subjected to the exacting tests established in Chapman versus California, that the error is harmless if the government can demonstrate beyond a reasonable doubt that the error complained of did not contribute to the verdict obtained. Even under plain error, the question is whether it affected Mr. Williams' substantial rights. And this court has recognized that the right to confront accusers is essential to fairness to ensure the integrity of the process. And that was in this court's decision in Wills in 2016. What happened here was an impermissible end run around Mr. Williams' substantial rights. And in this way, there was a reasonable probability that this error had a prejudicial effect on the outcome of the joint trial for Mr. Williams. And so now I'll turn lastly to the ineffective assistance of counsel piece. The government noted that the defense attorney in this case early on asked about the possibility of a plea and didn't push it to build trust. But then there was an obligation over the next several months to revisit that issue, especially as the facts changed. There was evidence mounting. There was this mention of the homicide count. By the way, even if it was referring to a past discussion, there was only one discussion that was before the July 2017 hearing. And I would just note that in the context of effective assistance of counsel with pleas, the Supreme Court has noted that we have a system of pleas, not a system of trials. And therefore, the negotiation of a plea bargain rather than the unfolding of a trial is almost always the critical point for a defendant. That's from Fry. And the last thing I would note, just in terms of the government's willingness to extend a plea offer to Mr. Williams, I would point to the other defendant originally in this case, Mr. Pugh, who, unlike Mr. Williams, had a long criminal record and was on probation for weapons charges at the time of the shooting, and yet got 8 years for murder too. That shows that the government was willing to offer pleas and for well less.
Although you'd acknowledge that he was pretty differently situated in that if he was telling the truth, he wasn't an actual shooter and he testified. And so there were the kind of other circumstances that would have been highly relevant to what pleas a prosecutor would be willing to extend.
That's true, Your Honor. He also had the record and was also the driver, in the car that night.
But isn't that also confirmation that if Pugh, who was less involved, got murdered too, the government was unlikely to go below that for your client?
I would agree that the government would not be inclined to give less than 8 years to Mr. Williams, but I would argue that it shows that the government would be inclined to give him less than 24 years, which is what he received after the full trial.
Although there too, the 24-year figure was your client's testimony that at the post-trial hearing that he would have accepted a guilty plea, I assume to murder too, as long as the allocution was capped at 24 years or some number. I forget whether it was 24 or less than 24, but I thought the trial court explicitly did not credit that testimony.
Sorry, I didn't follow the.
You were just making the point that in response to Judge Alicon's question, sort of acknowledging, well, maybe murder two would have been the charge, but the issue would have been the sentence, and you picked the number 24, which is where the trial court settled. I know, but it's also your client had testified at the hearing that he would have been open to a plea as long as the sentence was capped at, I forget whether it's 24 or less than 24. And I was just asking, essentially, isn't it correct, though, that the trial court did not credit that aspect of your client's testimony?
That's true.
I mean, isn't that testimony inherently non-credible? I mean, given that the number 24 could only have come into could have been coincidence, I suppose, but before trial and sentencing, how would your client have come up with the number 24.
I'm not sure how my client, Mr. Williams, would have come up with the number exactly 24, although, there had been in DC, sentences less than 24 years for murder two while armed, in the previous year. And so I think just thinking about that range, and that, right, if he was offered a plea of in the high teens, that would have been what he would have been interested in.
Thank you, Counsel.
Thank
My
you.
colleagues have further questions? Mr. Laughlin?
Thank you. For the reasons that your honors have touched upon, there's no evidence in this record that Mr. Knight took any action with the specific intent to prevent Mr. Williams, arrest, trial, or punishment, or to hinder or delay any official proceeding. Under these circumstances, a pre-existing relationship militated towards this just being a friend, allowing a friend to stay with his girlfriend. On these facts, there's no.
Can I ask you a question? I haven't gone back to check the instructions on this point, but it is a standard jury instruction that fact finders are permitted to infer that people intend the natural and probable or natural and ordinary consequences of what they do. And do you know off the top of your head whether an instruction like that was given in this case?
I do not know off the top of my head, but I could.
And I guess the argument with respect to at least staying at the girlfriend's home, one could say, perhaps relying on that instruction, that taking as a given that Mr. Knight would have known at this point that the police were trying to locate Mr. Williams, providing him shelter at Mr. Knight's girlfriend's place would operate to help make it difficult for the police to find Mr. Knight. They wouldn't have any particular reason, or well, I mean, depending on how much information they know, that might make it harder to find them than it otherwise would have been. It would tends to be a place that they wouldn't, unless they knew some detailed information, look for him. So do you think that the fact that he's assuming that the jury concluded that he was aware of that the police were looking for Mr. Williams, and that he asked his girlfriend, can he stay with you, if the natural consequence of that is to make it harder for the police to find Mr. Williams, could a fact finder infer that that's what Mr. Knight intended?
I don't think there's enough there to infer intent from that, given that ultimately Mr. Williams wasn't apprehended at Miss Williams' location, which stands reason that the police knew her to be a known associate of Mr. Knight and Mr. Williams, and at some point did effectuate an arrest at that location. So quote unquote, hiding Mr. Williams at a place where he reasonably should have suspected the police would eventually search would seem to be counterintuitive to the specific intent required under either the accessory or the obstruction statutes.
Can I ask you another question, I guess, about what inferences a fact finder could draw? I think the United States was maybe hinting at this in its argument, but if one could a fact finder look at this case this way, we know that the police told Mr. Knight, we're looking for Mr. Williams, and you could be criminally charged if you help him, if you harbor him, if you assist him in any way. And yet Mr. Knight, if the fact finder could find, provided that assistance. And is there an inference that a fact finder could draw that he must have had some pretty strong reasons to do that, more than, I mean, I think I'm a pretty good friend to folks, but I'd be pretty leery of, helping them stay at a acquaintance's house or something like that. If I was aware that the police were looking at them, and if I'd been personally threatened with possible criminal prosecution if I did it. Which is there any inference there that a fact finder could think, wow, if he was willing to do that, having been warned that his purposes were probably just not ordinary friendship, and there was something more than that?
I think that type of inference would be tenuous, specifically given the temporal disconnect between the second interaction with police and the ultimate arrest. He would have had to have known that Mr. Williams was still being sought by the police, despite having limited to no contacts with the police during those intervening 5 months. There's a presumption, I think, embedded in that question that Mr. Knight was kept abreast of the status of the police's investigation, or whether or not, for instance, Mr. Williams might have cleared things up with the police and they had moved on in their investigation. At the subsequent to the February 2016 search at his residence, for all Mr. Knight knew, this was a water under the bridge issue. The police had moved on and were investigating someone or something else. I think there's.
Can I ask you, I guess the third point the United States was making, I'm interested in your response to, is essentially an argument that the evidence about Mr. Knight's response upon learning of the arrest of Mr. Williams itself suggests or permits an inference as to intent to interfere rather than just kind of mere neutral friendship. Both this expression of dismay, I guess one could say, maybe an argument that he wasn't really candid with his girlfriend about Mr. Williams's known circumstances, and then his reference about trying to pin a body and all that. There's an argument that the United States makes that a reasonable fact finder could look at that and view it as inculpatory and supporting an inference of bad intent rather than sort of neutral. I'm just, not trying to interfere with what the police are doing. I just am being a friend in the way I normally would. I'm interested in your response to what's your take on those statements and why those statements don't reasonably contribute to an inference of bad purpose.
I think, sadly, given the state of relations between the public and the police, I think the inference cuts the direction that there's an investigation going on of me, and I don't want to be caught up in this necessarily. So I don't think it necessarily flows to any ill intent with regards to Mr. Williams, so much as a reasoned instinct towards self-preservation and avoiding any type of further interaction with the police relative to his own potential legal exposure for a potential murder charge. Just on the face of the statements themselves, I think that's at least as reasonable, it's set of inferences to draw from what he said. He's at least as concerned with having the murder pinned on him as he was with whatever investigation the police were engaged in with regards to Mr. Williams.
I mean, that seems, I don't want to belabor the point, but that seems to cut the other direction. I mean, it seems like a jury could reasonably consider the relevance of the fact that the harborer is also implicated in the crime and therefore has the view that if this guy goes down, I'm going down too. And that shows intent to harbor as opposed to intent to just sort of help a buddy out.
In perhaps, but I don't think that this record necessarily supports that inference. I think that the record that we have in front of us is that there's a pre-existing friendly relationship. There was no specific intent in actions taken within the normal ambit of that friendship that would lead to an inference that he had a specific intent to impede the police from doing their jobs and ultimately apprehending Mr. Williams for this offense.
Thank you, counsel. Unless my colleagues have further questions, we thank the parties and for their briefs and for their arguments today, and the cases will be submitted. We'll call now the second case. The second case on this morning's calendar is LDP Acquisitions LLC versus Captain Reed 2640 LLC and some consolidated appeals. The appeal numbers are 22 CV 62, 22 CV 97, and 22 CV 531. We'll hear first from Mr. Johnson.
Thank you, Judge McLeese. May it please the court, Vernon Johnson from Nixon Peabody for the appellant on two of the appeals, LDP Acquisitions LLC. With me at council tables, my colleague Louis E. Dolan Jr. and our paralegals in the courtroom as well, Caroline Taylor. She's assisted us considerably with this case.
Can I interrupt for a second? I realize this is, I guess, appeal, cross appeal, and we haven't really discussed the format for that. I guess I tend to think it'll be easy enough for us to just have a first argument where you address all the issues and your opponent will address all the issues and you'll have a reply. If people feel strongly otherwise, I'm open to that. But
I guess I was assuming we would do the 15-15 and I was going to ask to reserve 3 minutes for rebuttal, and that
sounds good.
I would think would be sufficient.
Excellent. Thank you.
Our client LDP Acquisitions is a top-down diverse real estate developer based in the District of Columbia. They have offices on 16th Street Northwest, and they are a prolific developer, owner, manager of mixed use, commercial, retail, residential properties, and multifamily apartment complex properties in the Washington, D.C. area and nationally. And the project and the properties that brings us here today is a compilation of 9 lots near the red line, literally one of the last undeveloped areas near the red line of the metro in Washington, D.C. And in 2019, the owner of those properties, Captain Reed 2640 LLC, which is the defendant appellee in these cases and also the cross appellant, made it known that these properties would be offered for sale. And what ended up happening is several developers expressed an interest, including LDP Acquisitions and including another company that is a non-party but filed an amicus brief, Hanover RS Limited Partnership, which is a Houston, Texas-based developer. And the series of events that took place in 2019-2020 resulted in Captain Reed deciding that they wanted to enter into a letter of intent with Hanover, and they had an exclusive period to negotiate with Hanover. And after that expired and they had not reached contract, Captain Reed then started dealing with LDP Acquisitions from about October of 2020 through sometime in the summer of 2021. LDP Acquisitions and Captain Reed were actively in negotiations. And this culminated in a May 1st, 2021 letter of intent, which was attached to the complaint and is part of the joint appendix in the case. And the letter of intent had a number of provisions, and there were also a number of relevant activities taking place in 2021, including LDP Acquisitions obtained some very valuable entitlements benefiting these properties.
So, sorry, counsel, to interrupt you. Would you agree that there were continuing negotiations between your client and Captain Reed after the engagement on the letter of intent?
Yes.
And is it your position that all of those negotiations following entering into the letter of intent were in bad faith?
Well, we don't know the full extent to when the bad faith developed.
Well, okay, so let me flip the question. Would you say that there were some good faith negotiations between your client and Captain Reed that followed the entering into the letter of intent?
We certainly thought that there were, and we were led to believe that Captain Reed was negotiating in good faith, and there were related representations and statements by authorized agents of Captain Reed, including Andrew Ross, and those are alleged directly in the complaint. And obviously,
Asking a question, a variant of that, if you were going to point to evidence that there was bad faith negotiation, either, let's say, before the no shop period ended, let's take that period first, what evidence is there that there was bad faith negotiation at that point alleged in the complaint?
We don't have a lot of evidence, and part of the problem with how the case was short circuited for us is we didn't get discovery on any of the real full extent of the discussions that were taking place between Hanover and Captain Reed.
I take that point, but do you even allege bad faith in your complaint?
I'm not sure that we allege bad faith or that we would have had a basis at the time. I mean, frankly, one of the things that's been interesting in how this has played out on appeal is we've learned a lot more on the appeal, including information in the amicus brief that we never knew. But what we alleged in the complaint was that there was an obligation, a type 2 preliminary agreement to negotiate in good faith towards a purchase and sale agreement.
Can I ask you just to slow down? What in the letter of intent imposes an obligation to negotiate at all, much less in good faith during the no shop period?
That obligation is expressly set forth in paragraph 3 of the letter of intent, and it literally
And
says.
why do you call it an obligation if the letter of intent says this is a non-binding expression of interest under which no one shall have any liability or obligation except for the provisions of sections 12 and 13 and 14?
And
So how do you call it an obligation in the letter of intent if the letter of intent seems to expressly say it's not an obligation?
but it doesn't say that there's no obligation. The paragraph 3 is pretty clear that there is.
When you say it doesn't say, do you mean paragraph 3 doesn't say, or are you saying the settlement, the letter of intent doesn't say there's no obligation?
Paragraph 3 doesn't say it. There is language in the letter of intent that you could read as undercutting our claim, which is part of the reason it was inappropriate for the Superior Court to short circuit all this and say, we're not going to allow you to reach the merits. I mean, it's a letter of intent, and standard language in letters of intent does say we're not obligated to reach a final agreement. And perhaps and this is part of the problem with, I think, how Judge Epstein construed the case. He construed every one of our claims much more narrowly than was appropriate, and that.
But I think Judge McLeese's question wasn't about the obligation to reach an agreement on the sale and purchase, but the obligation to negotiate in good faith. And you said it arose from paragraph 3. And I think the question was paragraph 3 wasn't one of the identified paragraphs that Captain Reed was potentially bound to. So what is the source of a binding obligation on the part of Captain Reed to negotiate in good faith?
It's paragraph 3 and the other discussions that the parties were having. Paragraph 3 is quite explicit that it says seller and purchaser shall use diligent good faith efforts to fully negotiate and execute the purchase agreement materially consistent with the terms set forth in this letter of intent. That's at page 28 of the joint appendix. You can't read that provision out of existence by saying that there was exculpatory language somewhere else in the letter of intent, particularly given.
Why can't you? I mean, it seems to me it's an interesting question. You could say that one way of looking at it is paragraph 3 seems to state an obligation. There's another place where it says anything that seems like it states an obligation doesn't state an obligation unless it's in paragraph 12, 13, and 14. That is a question of contract interpretation, how to reconcile those provisions if you think they're conflicting. Are you saying as a matter of law, the only way to read it is that there is a duty not only to negotiate, but also to negotiate in good faith? Or are you saying that maybe that contract is points in both directions and therefore is ambiguous and maybe extrinsic evidence should have been admitted? Or I'm just not quite sure what your theory is, but to the extent your theory is, if you look at that as a matter of law, the only way to read it is that there was a duty to negotiate and to negotiate in good faith. That seems like a tough.
Judge McLeese, we're not arguing that as a matter of law, we would have been entitled to summary judgment, for example. But I think when you take into account all the surrounding factual circumstances, including LDP acquisitions, getting the entitlements, the discussions that were taking place from October of 2020 through the summer of 2021.
I mean, I don't have a commercial background, so I don't really have a good sense of all the different forms of letters of intent and no shop agreements and the like. If you look at cases around the country, you can see they take a variety of forms, and some of them will have express requirements to negotiate during a no shop provision. Some of them will it's just a no shop provision. And it's like, we're hoping to reach an agreement. One of the things in our letter of intent in advance is one of the two parties is not going to go try to shop it anywhere else, but there's just nothing about negotiation. And there's some cases around the country that will say, when it's something like that, there's no obligation to negotiate. It's just the parties are they haven't agreed that there are no binding promises to negotiate. There's a binding promise not to shop. And so it seems like there are a variety of ways these letters of intent can be drafted. And but I take it your point is, at least one of your point, you're not arguing that the contract unambiguously imposed an obligation of to negotiate during the no shop period and to negotiate in good faith. Your argument instead is to at least acknowledge at best it's ambiguous and maybe there should have been further factual development and extrinsic evidence and the like.
No, of course, we wanted to get the ability to take discovery and find out what was really going on. And Judge Schenker, there is an overall obligation under District of Columbia law to exercise good faith and fair dealing, and that would have applied here as well.
Well, see, that's puzzling to me too. If the contract is read correctly to say there's no obligation to negotiate during this period, then although there would be a duty of good faith with respect to the binding obligations that are established in the contract, if that's not one of them, I'm not quite sure how logically you would infer such duty of, to operate in good faith and fair dealing. You wouldn't think would extend to anything that is unambiguously not an obligation in the contract. It would only, I would think, be with respect to the obligations in the contract.
Perhaps that's true. The factual situation that we have at bar, though, there is express language saying we will negotiate in good faith. And there was an obligation to do that, which makes it.
Well, again, you say there's an obligation to do that. You're acknowledging, not as a matter of law, your claim is that if you had adequate discovery, you would have been able to at least survive summary judgment on the question of whether the right way of reconciling arguably conflicting provisions in the letter of intent would be that the letter of intent was properly construed to impose an obligation to negotiate during the no shop period, and not only to do that, but to do so in good faith. But you're not really. You're not really here arguing that we should say, as a matter of law, this contract can be understood to impose an obligation to bargain in good faith. And I thought your brief was saying that, but that's why I've taken you so far an argument to be backing off of that and to say something short of that, which is, no, we should have had a fair opportunity to show that one way of reading this contract, all things considered, would have been that there was such a duty.
At the motion to dismiss stage, the question is, did we state plausible claims? We were arguing that there is a plausible claim stated there. It isn't, as a matter of law, it isn't summary judgment at this point, but it entitles us to move forward, get discovery, and have the claim adjudicated on the merits. And
if you on the question of whether the contract is even ambiguous on this topic, I mean, are you aware of case law that addresses what seems to be our situation, which is there is a paragraph in a contract that in isolation is worded as imposing an obligation. But then there is an overarching provision in the contract that says, of all the things that sound like there are agreements here, there's only 3 of them that are binding. I mean, do you have law that we should be looking at for the idea that that creates an ambiguity rather than a pretty clear conclusion, which is the right way of reconciling that is to kind of take the explicit provision that is referring to other provisions that in isolation seem like they're mandatory and explaining that they are not. Is there some cases or case law that you point us to about the idea that creates an ambiguity rather than a relatively straightforward way of reconciling 2 provisions?
This court has many cases that deal with contract interpretation and whether there's an ambiguity and whether which means it's reasonably susceptible of alternative interpretations. And I think you can certainly argue that this one is.
Well, what is the, I mean, unless you think, I mean, it seems to me that the best case for you is that there are 2 conflicting provisions. But if you don't view them as conflicting, then what do you think happened here?
Judgment, please.
What's the reasonable interpretation of that language other than either they said they're talking out of both sides of their mouth and not making sense, or they are explaining that there are a bunch of things that we're kind of agreeing to in a moral way, but not in a legally binding way. And the legally binding ones are the ones that are in 12, 13, and 14.
Judge McLeese, I would argue that they are not internally inconsistent. The thrust of the LOI is to say, if we don't reach an agreement, if you don't end up being able to acquire these properties, we may not have liability. But short of that, we are both undertaking to negotiate in good faith, and we've set out the framework for that, including purchase price and other terms.
So, okay, so then can I turn to what your remedy would be? I mean, you've acknowledged that your claim is not that there was an obligation to enter into a sale agreement, purchase and sale agreement, but that the breach was against the obligation to negotiate in good faith. So what's your remedy now? I mean, you're not saying that they're bound to now offer you the property, right?
They're bound to negotiate in good faith, and we could get an order for specific performance directing them.
But
to
what
do
would
that.
that mean? I mean,
It would mean that
they
they
have
have,
to sit down with you in a conference room for 5 minutes and then say, sorry, we've already sold the property to somebody else, but we appreciate your interest. I mean, would that satisfy? Would that be an adequate remedy?
I don't think 5 minutes would do it, but there would have to be a legitimate, good faith, arm's length negotiation. And if they have in fact sold the property to someone else, which I don't think is the case, they haven't gone to closing with someone else, and we'd have a damages claim that would relate to that. But the specific performance obligation most certainly can be enforced. This court in the United House of Prayer case.
But you're asking to specifically enforce paragraph 3, but the only paragraphs that can be specifically enforced are 12, 13, 14.
But I don't think that's correct. I think that it's saying that in terms of a liability for monetary damages, it's making it clear that the paragraphs that are mentioned can give rise to a claim. And one of them is the one with the LDP litigation costs. But it's not saying that it never says you can't have any obligation. You're not held to specific performance on any other.
Why do you say
part of
that? It
this.
says this is a non-binding expression of interest under which no one shall have any liability or obligation except for the provisions of 12, 13, and 14. I don't know how it could be said more clearly.
Which is the starting point for the discussions. But then when
Well, I was just saying, you were saying it never said something that it seems to me that it does explicitly say. Now I take your point that there are other provisions that read in isolation seem mandatory. I mean, there are others of them that I assume you don't think could be specifically enforced. I don't think you could. I mean, number 9 is the seller shall deliver the property in free and clear title. I don't think you could. You would agree you can't get specific performance of paragraph 9.
not at this point, because we aren't having a closing.
Understood.
But you also,
Yet it is in categorical terms.
and I think reading it at its logical meaning, you're talking about if you get to a closing, there are certain conditions that everybody has agreed at this point as a material term that these are the conditions. I don't
And the
think,
point I'm making more generally is that, at least arguably, the existence of other paragraphs in the letter of intent that are worded in categorical terms shows, this is arguably, I'm not saying this is my view, I'm just saying it seems like an argument that it can be made, that the letter of intent didn't mean that all of these paragraphs were intended to be mandatory. They were all written as like, here's the plan. It's not a binding plan, but it's all written in mandatory terms. But just in case you're confused, nobody's going to be bound to anything except in 12, 13, 14. And it seems like certainly a quite reasonable way of trying to reconcile it. The question for you in part is there another reasonable way of reading it that allows you to survive dismissal and get, into the world of discovery and summary judgment?
and I think there is, especially when you take into account the surrounding facts and circumstances, which include the entitlements that LDP Acquisitions was going out and spending time and effort to get, and with the full knowledge and approval of Captain Reed at the relevant time, including after the LOI was entered into. And then there are discussions that are taking place including the specific discussions in June of 2021, where Captain Reed is saying, we have an agreement, we've reached an agreement on all the material terms, but we don't want to memorialize it yet because we have this other lawsuit with Hanover and we don't want to give them ammunition for that other lawsuit. So there's more to it here than just the LOI. The case doesn't start, stop, and end with the LOI.
But
There
isn't
also
that
are the other
exactly
facts.
why it was an LOI and not a binding contract to enter into a purchase and sale agreement? It covered the fact that any contingencies could arise at any point, and as long as they negotiated in good faith up to that point, they could decide for any reason whatsoever that they didn't want to enter into a purchase and sale agreement with you, right?
And I don't agree with that. I think that's overstating the point, especially when you are being told, we have a deal, we've reached an agreement on the material terms. Let's not memorialize it yet because of this other lawsuit that Hanover has filed, and we don't want to give them
But you
ammunition for
but you
that.
were on notice of that, right? I mean, that's why Hanover filed the lease pendants in their action.
We
So
were,
you bore the risk of that happening.
well, so this gets into the Liz Pendens issue, which
Well, I'm talking about Hanover's lease pendants, though.
we certainly knew about Hanover's suit because LDP Acquisitions was joined in the suit until it was dismissed on August 19th of 2021. But it was a party. So there was a Liz Pendens, but we also had a notice of the lawsuit and were involved in the litigation and the discovery of that lawsuit. And I don't know if you are asking or wanting to segue into the Liz Pendens issues, which I do think pose some interesting issues here in terms of the argument that's being made that there was a secret settlement between Hanover and Captain Reed in that case, and somehow it binds LDP Acquisitions because there was a Liz Pendens. I don't see any way that that could be the case or that that's at all consistent with this court's prior rulings or the statutory scheme under DC Code 42-1207. There's just no way that a dismissal with prejudice of a claim that was subject to a Liz Pendens somehow turns into something that binds a party that had absolutely no information about a settlement or about what was being done. There's no mechanism under the statute to do that. And it's not possible that that could have happened, but that's one of the arguments that is being made. It was not relied on by the Superior Court, but it's one of the arguments that's being made to defend the ruling canceling the Liz Pendens.
So counsel, you're over time already, and I know you had, I think, maybe 4 other topics that are in your brief. So we will give you a little bit more time if you want to pick 1 or 2 of those that you want to say something quickly about, and then we will give you a couple minutes of rebuttal. But I just want to let you know you're over time, and if you have critical issues you want to address, now would be the time.
Understood. Let me just make a 3 or 4 brief points here, and I'm glad to answer any questions. We were wrongly short-circuited on a 12B6 motion to dismiss. The plausibility standard governs, and the claims were more than plausibly stated. The Liz Pendens was also canceled in a way that the statute doesn't provide for. If you read 42-1207, it actually provides that if there is a claim that for which it's proper to file a Liz Pendens, that it stays in place even if there's a judgment in the Superior Court resolving that claim against the party that filed the Liz Pendens. That judgment can't be recorded among the land records until the appeal period.
Well, has it been recorded? I mean, I thought Captain Reed said it has not been recorded yet.
The Captain Reed judgment?
Right. Yeah, no, the judgment in favor of Captain Reed on both your motion to, your complaint, dismissing your complaint and summary judgment in their favor. Has that judgment been recorded yet? By
Right. There wasn't really a judgment. It was an order that Judge Epstein entered. I don't think any judgment.
Well, there's a judgment now, right? After summary judgment was granted.
There's a judgment as entering a final order in the litigation, but I don't think there's any judgment with respect to the Liz Pendens.
No, but the judgment in the matter, has that been recorded yet by Captain Reed, given that this appeal is pending?
Not to my knowledge.
Okay, so then how does that violate what it is that you're claiming the statute says.
Well, because the order that Judge Epstein entered purported to say it's an immediate cancellation of the lis pendens.
But
Well,
that's, sorry. go ahead.
Are you saying it's premature because the case wasn't fully dismissed at that point? But if so, it seems kind of academic. Do you agree that at the time of the summary judgment order completely terminating the claims in the case, the trial court could permissibly under 42-1207 D1 have included in that judgment, by the way, the lis pendens is canceled?
I think so, but the prior order purported to cancel the lis pendens. That's part of what was.
Understood, but is your only point, I was trying to figure out, is your only point that was premature and that really should have been in the later judgment?
It was premature,
But you agree that it could have properly been in the later judgment?
but it couldn't have been recorded until this
Understood,
appeal was
which,
decided.
understood. I'm just asking now about could it be in the later judgment? And what's,
correct.
assuming that that's the only nature of your claim of error, what's the prejudice to your client that it's written down in the wrong, on the wrong piece of paper?
Well, the order itself canceling the lis pendens was not only improper because it was related to the motion to dismiss, but canceling a lis pendens is reserved for situations like the one in McNair Builders.
See,
where
now you
have
seem
a
like you're
void
back around
claim.
to the merits. I thought you were agreeing that when the trial judge wrote the final order on summary judgment terminating the case in toto, the words, the lis pendens is canceled, could have been on that piece of paper.
I think that's right.
And if that's true, I'm just back around, what's the prejudice to your client that those words are on the wrong piece of paper?
It's wrapped up in the fact that our equitable lien claims and our other claims were dismissed on the motion to dismiss. That's really the prejudice. We're not, and we don't know fully what additional prejudice there might be if somebody were to argue, for example, your lis pendens was canceled, therefore.
Let me
we
make sure
took
I
it-
follow your point. Are you saying that if we were to grant you relief on some of the counts, that the logic of that should be that the cancellation, we should make clear that there shouldn't be a cancellation right now?
Correct.
I get that. Are you arguing, assume that we were otherwise inclined to affirm with respect to your claims? Do you have an independent claim of prejudice with respect to the cancellation of the lis pendens?
The prejudice would be to the extent that somebody acquired an interest in between the time that the cancellation order was issued and we were allowed to move forward with our claims. If we lose on all our claims, we don't have an issue. Perhaps that's what
That's what I
you're
was
asking.
Thank you.
The other point that I'd like to make just briefly is on the cross appeal. As we've argued, the standard of review is abuse of discretion. They don't cite that standard of review, nor do they ever argue that there was an abuse of discretion. Really, that appeal on the denial of sanctions is a nullity. They haven't argued that the standard that would allow you to reverse on that even applies. We would ask that the judgment on summary judgment as well be reversed and that the case be remanded for further proceedings so we can pursue claims on the merits.
Thank you, counsel. We'll give you your 3 minutes of rebuttal.
Thank you.
Morning, Your Honors. My name is Mark Titici. With me at council table is Ashley Paxton Turner, Ken Barras, my partner in the audience with this as well. I represent the appellee and cross appellant Captain Reed. Your Honors, I guess I'll start where you spent the bulk of the time with opposing counsel, which is on the contract claim and the language of the agreement. I think it was Judge McLeese who said it's hard to envision a clearer expression of intent not to be bound by specific provisions of a written document between two parties that says that there shall be no one shall have any liability or obligation except for the provisions of section 12 and 13 and 14. The obligation to negotiate in good faith is in paragraph 3, not paragraph 12 and 13 and 14. It's pretty clear that LDP's entire case is premised on an obligation to negotiate toward an ultimate execution of a purchase and sale agreement, which is not a binding obligation that Captain Reed took on itself that the parties agreed to in executing this agreement. Even if there were such an obligation, LDP has pleaded in paragraph 29 of its complaint that there were no negotiations between Captain Reed and Hanover between October 2020 and August of 2021, i.e. the person they are now in briefs and in pleadings saying we were in bad faith negotiations with, they have pleaded to the contrary. They are stuck with that concession in their pleading. We didn't have, this isn't Stanford Hotels. This isn't a case where you have someone negotiating a deal on the side. They have pleaded away that supposition that they're making now before this court and in their brief here, but
Well, even before they pleaded it away, they contracted it away, correct? Because I
Yes,
think that
they-
the
I
good
mean,
faith clause in Stanford was actually part of the obligations that were enforceable.
that's right. And the seller in that case conceded, Your Honor, that they were under a binding obligation to proceed with the negotiation and sale.
The point you're making seems to suggest that the only way in which your client could have shown bad faith in negotiations is by negotiating with Hanover, but that doesn't seem necessarily true. Your client could have, refused to negotiate at all if there had been an obligation to negotiate in bad faith. So I'm not quite sure that I see the equation that you were assuming.
I think that's true. Your Honor. Academically, I suppose that's possible. They also say in paragraph 35 of their complaint that we engaged in extensive detailed negotiations with them through July of 2021. I think you marry those two things together. An absence of any allegation of non-negotiation, or to, I think, Judge Shanker, your position, bad faith negotiations with them, and the fact that we weren't negotiating with Hanover, there's no plausible allegation anywhere of any kind of bad faith. There's nothing that supports that inference, even again, on a motion to dismiss standard.
So, I mean, suppose we all accept that there's no contractual obligation to enter into a purchase and sale agreement, and that there's no contractual obligation to negotiate in good faith. Is it also your position that there is no sort of extrinsic obligation outside of the corner of the contract to negotiate in good faith, whether arising from sort of an implicit obligation in all business relations to operate in good faith, or the fact that this is a type 2 preliminary agreement that carries with it an obligation to negotiate in good faith?
I'm going to sever negotiate and good faith there. I think there's an obligation to operate toward them in good faith. I don't believe there's an obligation to negotiate if we at some point decided in the course of, even during the 60-day no-shop period, decided, we just don't want to go any further here. We've hit an impasse. We don't think this is a good deal for us for any reason or no reason. I don't believe there was an obligation through the contract or extrinsically imposed to negotiate. I think, though, whatever we did with them, we did have to do in good faith. I think that my friend on the other side is right, that there's an obligation to just deal in good faith in commercial dealings under it hasn't been pled here, but the implied duty of good faith and fair dealing. And I agree with that. But again, going back to the allegations of the complaint, there are no specific allegations, factual allegations that support an inference of bad faith here that would violate that. And again, contrary allegations as to our dealings with them and with Hanover as well. Your Honor, I wanted to just pivot to talk about the quantum merit and unjust enrichment claim, because I think this is one, perhaps somewhat ironically, where we end up talking about one of the 3 binding provisions of the LOI. The premise of this claim for LDP seems to be that there's a certain amount of buyer's remorse with the deal they struck in paragraph 12 of the LOI. It says very specifically the circumstances in which LDP can be compensated or will receive remuneration for the work that it did in connection with the property. It says that they will get that remuneration in the circumstances where where Captain Reed enters into a purchase and sale agreement for the property during the pendency of the no-shop period. And it specifies how they'll be paid. They'll be refunded for the costs they or their third-party contractors expended, and they'll get a 5% profit on that amount. There is nothing about the claim they're seeking now, which is essentially they want to receive a share of or all of the increased value of the property.
But do you agree as a matter of law, you could plead breach of contract and quantum merit in the alternative?
In some circumstances, I think that's right, Your Honor. I think, and I think they cite a case where that has happened, where a party renders performance under the reasonable good faith, but ultimately mistaken belief that it was contractually obligated to render that performance. And then, yes, in that circumstance, there is a contract, a binding contract between the parties. And also you can have sitting alongside it a claim for unjust enrichment.
So on that point, you disagree with the trial court, which I thought, citing a district court decision, said you're not allowed to plead those in the alternative.
I think it may be perhaps swept too broadly there. I think that on these facts, in almost all circumstances, you can't have those two sit side by side. I think there are a narrow set of circumstances where you can. I just don't think we have that
And
here.
there's a related question, but distinct from the pleading and the alternative is in some of our cases, and the trial court seem to recount language from them. It's as though there's a flat rule, which is if party A and party B have a contract and party B files an action against party A that sounds in quantum meruit, that just can't work. If there is a contract, there can't be quantum meruit.
Yeah.
That seems overbroad, and some of our cases seem to acknowledge that that's not quite right. And the issue
Yeah.
is really, is the quantum meruit claim sort of covered by the contract?
Yeah.
So you contract for something short of what you're asking for in quantum meruit, and then
Right.
you say, oh, I want quantum meruit as an add-on to a contract. That you can't do. The lines between what you can and can't do are a little blurry. But do you agree there's not a flat rule that the existence of a contract precludes a quantum meruit claim? It's got to be a more detailed analysis about what was covered by the contract and how the quantum meruit claim relates to what was resolved in the contract.
Yes, Your Honor. I mean, you can consider the hypothetical where two people are in business and one is also the landlord and rents an apartment. So yes, there's a lease contract between them, but that wouldn't, of course, bar a quantum meruit claim for something that arises in their business dealings. Yes, I think that there isn't some loose language or overbroad statements and to that effect. And again, I don't think that overbreadth is a problem here, because there is a contract that is binding that deals with the specific work that they are, or investment or effort that they are seeking compensation for through equity. Here is covered by a contract. It just provides conditions that I think, and a form of remuneration that they are unhappy with now in hindsight, but that's not the function of a quantum meruit claim.
And do you understand the trial court to essentially have ruled in the alternative on that narrower ground to say that, yes, the logical connection between this quantum meruit claim and what is covered by the contract means that a quantum meruit claim is really not available here?
I think so, Your Honor. I think when you look at the explanation for what it was, I think there's maybe a mismatch between some of the cases that it cited and then when it actually explained it. So yes, I do think that the substance of what it was saying was tracking that narrower ground here and all that it needed to say to resolve it here. I wanted to talk briefly. I'll circle back to, I think, fraud in the summary judgment, but just talking briefly about lis pendens. 1207 D1 talks about entry of judgment, of course, but McNair and Santorini Capital, both Martin versus Santorini Capital, both make very clear that when this court and the statute talk about entry of judgment, they mean resolving the claims that affect an interest in property, not just entry of judgment, because again, you're in a circumstance where you could have some claim, for example, the summary judgment claim here for litigation costs that could drag out for however long it drags out.
Do you think
But-
your friend on the other side has preserved this claim that it was technically incorrect because it was a judgment on a motion to dismiss rather than a summary judgment?
I don't think so, Your Honor. I don't know that that's, having, without the benefit of going page by page through his brief, it sounded unfamiliar to me, but again, I don't want to take a firm position on that or, put this suggestion of forfeiture on him. But it wasn't one that I understood to be the thrust of their argument, I guess, in going forward here. But I just wanted to make sure we underscore the point that if this court affirms on the contract and quantum meruit claims, those are the only two that deal with an interest in the property. If those two, the decision disposing of those two claims is affirmed, the lis pendens notice of cancellation should also be upheld, and the notice of lis pendens cancellation can be recorded. It hasn't been, but then it can be. And then again, from the interest of my client, this case can go forward. The deal can go forward. The property can move on. And that's really, I think, it sounds like now the understanding of opposing counsel is narrowed to the point where the only thing we're fighting about is whether the merits of those two claims should be affirmed or reversed. And the lis pendens will rise or fall based on that, which again, wasn't entirely what I understood the briefing to be, but that sounds like that's where we are now. And then briefly on the fraud claim, Your Honor, the fraud claim is interesting insofar as there's an obligation, of course, to plead knowing falsity. And this really seems to be a case where the only fact, there are three statements they point to over the 10 months of negotiations that are supposedly false. But the only fact that they point to showing knowing falsity, that those were false when made, really is the fact that the deal didn't close. There's nothing else in there. This isn't the kind of case where there was a promise that was made that was ultimately reneged, or they are showing that there were side negotiations going on, like in the Stanford Hotels case, and they've alleged that in the complaint. There really is no fact that renders it plausible, as opposed to merely possible, that those statements were knowingly false when made, other than the fact that the deal didn't close. And again, this court has been very clear that you can't have a fraud claim based exclusively on the fact that a deal didn't go forward, because then in every case, when a deal doesn't go forward, you would have an allegation that, well, you never meant to follow through on your promise. That's literally Hornbook law from Prosser on torts. And then finally, Your Honor, on LDP's claims, I want to speak briefly about the summary judgment action for litigation costs. I candidly don't understand sort of the substance of LDP's continuing objection to receiving those funds. There was a delivery of a check without reservation after a pretty significant history of back and forth, including an interstitial ruling from the Superior Court on what was required to dispose of that claim for litigation costs. A check was delivered without any further reservation of the
Right, but
to
counsel, I mean, the trial court gave you language to use and
Yeah.
said this will make it go away,
Yeah.
and you declined, refused, I don't know what the right word is, to use that precise language. Maybe that's not consequential for us, but do you have any reason why?
No, Your Honor, I don't think so. Candidly, not having been the person who sent the letter, I don't know sort of a mental sort of test, but I don't view the Superior Court's language as truly magic words. I think in hindsight, would it have been more prudent to simply copy and paste the language into the letter and say, as referenced on page such and such of the opinion, this is what we're doing, and maybe over explain a bit more what was going on to try to ameliorate the concern. But I think that given the history and given the references in the letter to the prior events in that history, in context, there's no ambiguity. I believe LDP says that the language is ambiguous, but ambiguity requires more than one plausible interpretation of the language. And at no point, either in the Superior Court or now, have they said what the plausible alternate explanation of or interpretation of that without reservation language is. I agree with Your Honor about the optics of not just using verbatim the language that was gift wrapped for us by the Superior Court.
Were you obligated to pay that money under paragraph 12?
We have never contested that obligation. Let me answer your question now. We have never sort of contested that. We are obligated to do so. There was initially a dispute about $15,000 of the money, but we have never contested that obligation.
And do you agree that having prevailed in the trial court on the theory that your offer to pay that amount was unconditional and unreserved and satisfied the trial court's prior order, and if you were to prevail on that point in this court, that you'd be judicially stopped from raising any claim against them to try to recover those funds?
Yes, Your Honor. Thank you for raising that question as well. Yes, I think that's the capstone on all this, is that there is a very strong judicial estoppel point to be made here if we were to prevail as well. Your Honor, I want to, if I could just address the sanctions briefly. I know I'm running short on time. The only point opposing counsel is, of course, right, that it's an abuse of discretion standard for challenging sanctions. But I think our view is that the Superior Court really seemed to be laboring under maybe a legal misconception, or made a couple of legal errors, I think, that take this into the circumstances where it should be asked to exercise its discretion again. And for one thing, it said that it believed it couldn't issue sanctions because it wasn't entering judgment. This is sort of the line we were talking about, or you were talking about with my colleague on the other side, about what constitutes a judgment for 1207 D1. And regardless of what you think it would have been at the time, now everyone I think would agree that and everyone does agree now, I believe judgment has been entered. Final judgment has been entered. It could now, upon getting the case back, consider that request for sanction. It could have before. It didn't believe it could, because it had disposed of all the claims that affected the property. So it could have then, it certainly can now, but it said that it didn't think it could. So that's one point. It also cited the fraud, the statements that went to the fraud allegations, and also the denial of summary judgment on the litigation costs claim. The problem there is that those don't speak to an interest in the property. The sanctions were, did this party abuse the lis pendens device? And its fraud claim and its demand for litigation costs had nothing to do with an interest in the property or whether it's asserted a frivolous property interest in order to delay property development or gum up the process of moving forward on a property. And so again, it relied on those two factors that are truly legally irrelevant when denying sanctions. And the final was the murkiness, it said, between type 1 and type 2 preliminary agreements. Again, for the reasons we've talked about, our position is this isn't even a type 2 preliminary agreement because it's not a binding agreement to negotiate. But even if it were, not even LDP, I think, has said that at the time the LOI was entered into, all material terms were agreed and they just needed to be reduced to writing, i.e. they don't say it's a type 1 agreement. So there really is there's no murkiness. There's no suggestion anywhere in the record that this could have been a type 1.
Did you seek sanctions against Hanover?
No, Your Honor, we settled that case. So no.
Sure, before you hadn't.
No.
Because I mean, it strikes me that what's good for the goose is good for the gander, right? So Hanover and LDP seem like they're doing the exact same thing to try and gain a business advantage. We might say as judges, they shouldn't be using the courts as part of their business negotiation tactics, but it seemed odd to me that you would request sanctions in this context, but not the other.
Yeah, and I'll caveat my understanding, Your Honor. I don't recall that having happened in the procedural history. No, I don't believe that it did. And there may have been separate reasons for that, but we were ultimately unable to get dismissal of that case when we had tried, and LDP of course was successful, which does bring in one of the larger ironies is that they succeeded on very similar arguments, getting themselves dismissed from that case, and are fighting them here now. But again, with the exception of sanctions, we ask for the Superior Court to be affirmed and then remanded for additional consideration on the sanctions question. Thank you, Your Honor.
Thank you, counsel. We'll give you your 3 minutes in rebuttal.
Thank you. What LDP Acquisitions knew in October 2020 and going all the way to June, July of 2021 is that they were negotiating with Captain Reed. Captain Reed ultimately was telling them, we have an agreement on all the material terms. We don't want to memorialize it right now because we'll give ammunition to Hanover for its lawsuit. In the meanwhile, LDP Acquisitions is generating entitlements that benefit the property to the tune of millions of dollars. And that is part of what we asserted as
acquiesced to waiting until September when discovery closed in the Hancock or Hanover litigation. I mean, if you thought that that had the potential to stymie your ultimate ability to buy the property, why wouldn't you either revise a contract, enter into a revised letter of intent, perhaps say in the event we wait, then we do want to be reimbursed for these costs.
And perhaps we could have done that in hindsight, but we didn't have any idea what was going on. And like I alluded to earlier, we found out a lot more just during this appeal than we ever found out in the trial court because we didn't get any discovery. But we now know that Hanover and Captain Reed colluded to dismiss Hanover's claims against Captain Reed and then try to couch them as a settlement and a judgment that binds LDP Acquisitions, which isn't even possible, particularly given that Hanover's claims regarding the property and saying that they had a contract to buy the property were dismissed with prejudice. And those are the circumstances that make it appropriate for an equitable lien claim to lie, which does validate a lis pendens under 42-1207. Judge Ali Khan, you had asked a question about whether we preserved our argument about the lis pendens being canceled. We did, and I think if you look at the record, one thing to point out is that the motion to dismiss and the motion to cancel the lis pendens were filed separately within about a week of each other. So they didn't move all at once to say, we want to dismiss your property related claims. And because of that, you don't have the right to a lis pendens.
I think the question was a little bit different. Although obviously Judge Ali Khan can speak for her question as well, but I understood her to be focusing, it was clear you were objecting to the cancellation of lis pendens. The question was, to the extent there was discussion today that part of your reasoning is that the 42-1207 D1 requires there to be a judgment, and at the time of the cancellation, there wasn't yet a judgment that was sufficiently sweeping. I think the question was, is that a point that you specifically made in the trial court?
We certainly
Or
did.
and in your brief in this court?
We certainly did brief 42-1207 D1, and we made the argument that once you have a claim that enables a lis pendens, that is not canceled of record until after the case is fully adjudicated.
And
On
you don't
appeal.
object that it was never recorded.
We didn't know what was recorded or what wasn't recorded in advance of an order being entered. I don't think we could have anticipated exactly how the court decided to deal with these issues. But we did say, when you make a valid claim, when you have a category of claims that falls within the 42-1207 affecting an interest in real estate, that is entitled to remain of record until after the appeals have been expired.
Right. My question is, my exact question was, did you make the specific point in the trial court or in your brief in this court that the summary judgment order was inadequate to trigger a cancellation authority under 42-1207 because it didn't fully dispose of all of the claims that could be the possible source for lis pendens? It wasn't a fully developed judgment as required. I wonder if you made that specific.
I'm not sure that we made that exact argument because that isn't what the trial court did. The trial court was presented with a motion to cancel the lis pendens, and the basis for it largely was this res judicata.
Well, I'm not sure. It seems to me that it would have been quite available to you to say to the trial court before ruling on the lis pendens, or in this court in your brief, to make the point that it's kind of developed an argument here, which is the idea that whatever else you think, you can't issue a cancellation order until you have terminated all the claims in this case, or all the claims that could support a lis pendens, which might be a somewhat more complicated analysis. It seems like it was a point that was fully available to be made in your lis pendens filings and in this court. And I just I don't remember having seen it in either of those places. And I'm taking from your answers that you don't recall it having been made specifically.
No, I believe that we did address the issue of when it's appropriate to have it canceled of record.
In abstract terms, yes, but again, you keep sort of, I'm asking a very specific question whether you made a specific point, and your answer tends to be, well, we address that general topic. But so I'm sort of taking by the nature of your response that you're not aware of that specific point being made.
Well, we did cite, and there's a footnote in our reply brief to McNair Builders, and then there's another case where there was an early cancellation, and we drew a distinction between what was done here and those cases. McNair is the mechanics lien case where they named the wrong person in the notice. It wasn't an owner, and they had an inadequate, insufficient property description, so it was void ab initio. We don't have a claim here that was void ab initio. It is a valid claim that authorizes a valid lis pendens, and that should stay of record until final judgment is entered and any appeals are decided.
Well, there you're losing me again. I thought you conceded that the trial court appropriately can issue a cancellation order once the case is over in the trial court. The question of what happens on appeal relates to the recordation of cancellation of lis pendens.
Right, I agree with you that there can be an order saying it should be canceled, but that still has to be reviewed. The appeal time has to expire
Before
or it
it
has
can
to
be recorded.
reviewed.
Only that only relates to the recording, and it seems undisputed that they haven't recorded it yet.
Correct, but I think the point is that when you have a notice, there are very limited grounds under the 2010 amendments to 42-1207. There are very limited grounds on which you can do an early cancellation.
And one of them is when judgment is entered in the case. And so even if that didn't occur when the court dismissed your complaint, it at least occurred when the court granted summary judgment.
And so
they
could have asked for that, but they didn't ask that be made part of the final order in the case. So there is no final order under D1 establishing a judgment that says the lis pendens is canceled. And Judge Epstein expressly said, I'm not acting under D1. I'm doing something different.
I don't recall him expressly saying he wasn't acting under D1.
page, in the portion of the
And
omnibus
he
order,
refers, he cited McNair, which is a D1 type case, right?
he did cite McNair, but in page 58 or 59 of the joint appendix, where he gives his rationale, he expressly says the court is not entering a judgment under D1. So he says he wasn't invoking D1.
You're over time. If you have a critical last point you'd like to make, feel free.
The only other point, there was a discussion about the summary judgment. Judge Schenker, your question, and Judge Ali Khan, your questions were right on point. I mean, it wouldn't have been very hard for them to say, we are not reserving any right to claw back this money or make another claim against you. They didn't do it. And it wasn't appropriate for the court to make a judgment on motive or intent at the summary judgment stage. I'm glad they're now admitting they'd be judicially stopped, but it would have been much easier and better for them to just say, we're making this payment because we owe it, which they're still denying in their answer. Paragraph 51 of the complaint makes the allegation. They don't admit that allegation in an unqualified way, and they were still maintaining they didn't owe the money. So that's why summary judgment was improperly granted. I know there were a lot of other issues that we briefed. I'm certainly glad to answer questions, and we would ask that the orders appealed from be reversed, that the denial of sanctions be affirmed, and that the case be remanded to the Superior Court for further proceedings consistent with the court's rulings.
Thank you, counsel. We appreciate your arguments today and your briefs, and the case is now submitted. We'll call the final case. Oh, the first case, sorry, I didn't, third case, I didn't call it in full. It's in re Kenneth Blackwell, case number 22 BG 565. Counsel, you may proceed. Yes, I think, although the order is otherwise, feel free to address us first.
Your Honor, first and foremost, I'd like to give glory to God for this day and thank God for my life and my presence here. Secondly, I want to indicate to the court, and the court is well aware, that the primary issue in this case concerns the payment of child support. The hearing committee noted that that was the central issue in this case to be considered. And the hearing committee also noted that neither the Court of Appeals nor the Board of Professional Responsibility has addressed whether disciplinary charges can be based on an attorney's failure to pay court-ordered child support. First, I want to present to this court the fact that this case warrants dismissal due to the undue, unreasonable, and unexplained delay by the Office of Disciplinary Counsel in prosecuting this matter, and the actual prejudice caused by the delay that resulted in the loss, destruction, or concealment of evidence that impaired my defense in this matter. Significantly, as the hearing committee found, the Office of Disciplinary Counsel did not address this delay argument. This court has clearly stated that tardy prosecution of potential offenders does a disservice to the attorney, to the affected clients, to the court, and to society in general. An undue delay in prosecuting casts an unjustified shadow over an innocent attorney. It allows a guilty one to practice with impunity. It dims memories and so distorts the truth-finding process. It threatens to put the integrity of the courts at the mercy of an unethical practitioner. It does nothing to deter other members of the bar from misconduct. and it erodes public confidence in the bar's announced intention to keep its own house in order.
So Mr. Blackwell,
That's from this.
I take your point that there was a delay in this, but and that, you know, in that delay, this notebook, this parenting notebook where you recorded your payments had gotten lost, but you were under court order to pay through the child support system, which would have kept records of this. And so I understand that you may have been prejudiced, but in some ways it's a prejudice of your own making by not following the letter of the court order.
Well, I disagree. What you're referencing is an event that occurred in 2007. It occurred only for that period of time. If you look at the orders that were issued in this case, the first order, well, the initial orders were consent orders that I entered into. Then on December 22nd, 2007, the court issued an order that the obligor shall make all payments until wage withholding is in effect and that are being withheld by the employer. Nowhere in that order does it indicate that payments should be made to any child support agency. Well, I beg your pardon on that. It says that payments are to be made to the Office of Child Support and Wage Lien commencing January 1st, 2008. So prior to that time, the payment was supposed to be made to the Child Support Office, and I admitted it was not.
And also, the notebook wasn't recording transactions at that point, was it? Or the notebook that was lost, was that recording transactions at that juncture, or was that? I thought that was a fair bit later when that notebook came into use.
No, the notebook use came in October of 2009. So again, I'm talking about the prejudice that occurred after 2009 as a result of that notebook, and that's a substantial period.
Is it fair? Is it fair though to say that with respect to whether there was a violation of the rule relating to obeying court orders, to the extent there was prejudice from the loss of the notebook, it doesn't go to the question of whether there was a violation, but instead to the magnitude of that violation, how long it lasted, and how much money that ought to have been paid was not paid either, directly or indirectly. But it doesn't really go to whether there was a violation. I thought you concede that there was a violation, and therefore it's appropriate to determine what the right sanction is, but you're not contesting that there was a violation of that rule. Is that correct or not correct?
Well, this court has stated that an undue delay in prosecution is not itself a proper ground for dismissal of charges of attorney misconduct. However, if a respondent demonstrates that an undue delay in prosecution impaired his defense, delay coupled with actual prejudice could result in a due process violation.
I get that, but so my question is in abstract form, the following. Imagine that there are disciplinary charges are brought against an attorney and there is undue delay. The attorney ends up responding by saying, yes, I admit I committed a violation, but it was nowhere near as extensive as disciplinary counsel alleges. And then there's a question about how to prove that. And it turns out that in the period of delay, some information that will be relevant to how the magnitude of the violation that is conceded, what its magnitude was. My question is really, is dismissal of the charge warranted then, or even if that was, there was that kind of prejudice, would instead something short of dismissal, for example, a determination that the misconduct, the conceded violation should not be dismissed, but instead its severity should be gauged as against what the respondent was reasonably able to address. That's my question really, is in a case like this where it seemed to me you were conceding a violation, whether even if there was delay and even if you were prejudiced in some respects, whether dismissal would be the right remedy or something short of that would be.
Well, yeah, I submit dismissal is the proper remedy for two reasons. First of all, there was a 3.5-year delay in the filing of charges. This concerned an issue of child support. No court in the United States would delay for 3.5 years in providing some assistance to a person who sought that remedy. 3.5.
I'm not quite sure. I'm not sure I follow your chain of reasoning there. Are you saying that part of the reason the charges, disciplinary charges, should be dismissed against you because there was delay in charges against you is because there should have been more rapid efforts by the court system to force you to comply with your obligations?
I'm saying that,
I'm-
and as
I'm
well,
not-
I'm saying that, but more importantly, I'm saying what this court has called an indispensable, and that is impairment of my defense. And that's what occurred by this delay.
Understood, but I guess my question is assume if you are conceding that you violated the disciplinary rule at issue, then one could say you don't have a defense to that, you're conceding. You may have had a defense to the magnitude of it, and if that was impaired, then maybe that should affect the sanction. But it shouldn't necessarily lead to dismissal of the charges or a determination that you didn't engage in the conceded violation. That's the question I'm trying to, I guess, discuss with you.
Well, Your Honor, to answer that question quite simply, this court needs to establish, this court has given a lot of verbiage to the fact that impairment of defense is critical, that it is a due process violation. This court has stated that actual prejudice does result from the delay, and if it does, that this court takes it very seriously. That's exactly what happened in this case. That prejudice is not dependent upon, it's an impairment to the defense. And it's relevant because disciplinary counsel has alleged that I did not pay substantially all that was paid. So that's a relevant issue in the case.
Do you dispute, is it your claim that you in fact paid substantially all of the child support payment that you were legally required to pay?
That is my claim. And the evidence supports that.
By substantially is a somewhat flexible term. So what's your understanding of the amount of child support you were required to pay during the period at issue?
You mean throughout that whole period? I haven't done a calculation of that.
So you don't know that. What does the record show about how much you claim to have paid?
What record are you referring to, Your Honor? Because let me answer that clearly.
Well, just to answer the question that you were asking, I'm talking about the record established at the evidentiary hearing in this disciplinary matter.
Well,
I'm saying, what does the record show about how much you paid? What is your claim? What did you claim? Look at your testimony. What did you concretely claim was the amount that you paid?
Your Honor, I paid substantially all that was due. If you want an exact figure, it may have been $2,000 short of what is owed. But again, that testimony.
If you're not sure how much you did owe, it's a little hard to know how you could know how short of it you were.
Because that information was contained in the visitation notebook. And that information was, the lack of that information prejudiced my case. Also, the testimony in this case by Ms. Al indicates that substantial amounts were paid. In fact, as the hearing committee noted, she had a selective memory, remembering more as to what was paid as opposed to what was, as what was not paid as opposed to what was paid. She was crossing.
Just to clarify one thing, to say that substantial amounts were paid is to say something quite different than to say one paid substantially all of what was required to be paid. But you're claiming, it sounds like you were suggesting today, your position is that you paid all but around $2,000 of what you were legally required to pay. Is that your statement here today?
Well, Your Honor, as the hearing committee noted, the record, disciplinary counsel failed to prove the amount of the shortcoming. It is their burden to show what was not paid. But the hearing committee concluded that if they show that any amount.
Well,
was
I
not
don't,
paid, that
Mr.
was-
Blackwell, I don't know if it was their obligation to show how much you didn't pay, because this wasn't really a child support case for them. This was the fact that or the allegation that you violated a bar rule by not complying with a court order. And it was really your defense that you had substantially complied with a court order by paying most of the child support. So it seems like at that point, the disciplinary counsel would be, or the hearing committee would be looking for you for evidence of how much you had paid. And that doesn't seem like you were able to provide that.
I would agree, Your Honor. And the fact that that evidence was lost, concealed, or destroyed with regard to the proof of what I paid occurred as a result of this undue and unexplained delay. My defense was hampered in that regard. You're quite correct. The hearing committee noted the burden shifted to me now to show how much was paid. So without that evidence that was lost, concealed, or destroyed by the
Well, that prejudiced you for the period of, that at most prejudiced you from the period of 2009 on. So that's not really relevant to a determination of how much shortfall, if any, or how much of a failure to comply with the rule there was before the time the notebook came into being. Would you agree with that?
Well, Your Honor, as I was about to get into it, it goes, if the court believes it does not warrant dismissal, it certainly warrants mitigation of the sanctions imposed. And that's what the court has also stated, that a delay in prosecuting the case may be a mitigating factor with respect to the discipline imposed and may result in a shorter period of discipline. So even if the court believes that that did not happen, certainly, as the court acknowledged, prejudice from 2009 until 2016, actually 2020, that's substantial. That's significant.
Can I ask you, this is, I guess, related to a question that Judge Olikan asked earlier, but during the period when I understand you to have conceded that you weren't complying with the order in the sense of at least following the process required by court order of submitting it to the child support agency, it sounds as though, as far as the evidence shows, you kept no records of what you were doing.
I'm sorry, Your Honor, you don't have to speak up just a little bit.
Yeah. Am I right that during the period, let's say there was a period of kind of informal consent orders and there was a period of a court order that required you to make payments through the Maryland authorities? Is it correct that as far as the evidence at the suppression, at the disciplinary hearing went, you presented no evidence of your own about any records you kept about what payments you made?
I did present records. I presented money orders that were sent to Ms. Allen at an address that she had no longer lived at and would not provide her current address so as to keep me from having contact with my child. Those money orders were returned. And
what time frame? Can you remind me what time frame that was?
what were the amounts?
Well, no, what time frame that was?
I believe they're in the record. I believe it was 2018.
Yeah, see, I because my question was at an earlier time frame, but
It's in the record, though. The disciplinary counsel produced a couple of receipts. Those were not the return ones, but the ones that were returned are in the record. And they're at exhibit, I can tell you that. Well, they're in the record at exhibit. I'll be able to identify that a little later. But again, it goes to mitigation, if not dismissal. This court has made clear in Fowler and in Ray Fowler that the circumstance of the individual case must be sufficiently unique and compelling to justify lessening what would otherwise be a sanction necessary to protect the public. And this is such a case. Again, this is a case of first impression before this court. The hearing committee noted that it had great difficulty in handling this case, and quote, disciplinary systems are ill suited to address issues surrounding deteriorating relations between the parties, such as arose in this case. They went on to say disciplinary systems are ill-equipped to balance the competing claims that respondent failed to pay what was required support, and that Ms. Allen withheld visitation in an effort to force respondent to pay support. Family courts and related entities were created to address these issues and have the expertise to address them.
you made reference to this topic a couple of times here at argument, and it almost sounds like you're suggesting that child support orders aren't the right kind of order to be the subject of a violation of Rule 3.1. But I had taken you to expressly concede that the fact that this order was a child support order is not a defense to determination that you violated Rule 3.1. Did I misunderstand your position?
No, I'm not saying that at all, Your Honor. I mean, I recognize clearly that Rule 3.1 or rather 3.4C applies to attorneys with regard to child support orders. There's no question about that. The question in this case is whether the undue and unreasonable delay prejudice my ability to defend in this matter. And as the court clearly stated, from 2009 to the time of the hearing, I was prejudiced by the loss, concealment, or destruction. The facts show disciplinary counsel did not even pursue that. It has an affirmative duty under 3.8 to do so.
Well, why do you say that? Rule The rule 3.8 is referred to as the special duties of a prosecutor, and one could think of disciplinary counsel as performing a prosecutorial function, but the specific rule in question says in a criminal case. So I'm a little unsure that it is directly applicable here.
Well, the board is, I think Mr. Fox conceded that Rule 3.8 applies to disciplinary counsel. That's been conceded in another proceeding before this court. I don't see how it could be any clearer. So,
Well, I think omitting in a criminal case would have made it clearer. In fact, one could say that imposing that obligation explicitly in criminal cases is a relatively clear indication that it isn't directly applicable to the function of disciplinary counsel. Not to say it wouldn't be relevant by analogy, for sure, but as to whether it's directly applicable, I think it could have been a lot clearer. In fact, one could wonder if it isn't in fact clear that it isn't directly applicable. I mean, you're not suggesting this is a criminal case.
beg your pardon, Your Honor?
You're not suggesting this is a criminal case.
No, Your Honor, but this court has called disciplinary proceedings quasi-criminal. And this court has also recognized that there are due process rights in disciplinary proceedings. I submit again by the plain language of Rule 3.8, the disciplinary counsel has an affirmative duty to investigate, to gather relevant evidence, to provide evidence either in mitigation or in defense. The rule is clear. So I don't think disciplinary counsel is shielded from that obligation. And you attach that also to the fact of a 3.5 year delay, unexplained. Disciplinary counsel has not even addressed the reason for this delay. If we go back to the time this complaint was filed on October 4th, 2016, disciplinary counsel was presented or somehow obtained a document from the Virginia Office of Child Support, which claimed that I owe $70,000 in child support. Why would there be a reason for a 3.5 year delay in bringing charges? So that would have benefited me. It would have benefited the disciplinary system. It would have also, because then the evidence would have been available. Also, during that delay, Ms. Allen claimed to have been prejudiced. She claimed to have suffered some hardship. That's highly questionable because one, she refused to accept payments from me during that period of time, the record shows. The record also shows, the transcript record, that I had contact with her during that period of time and offered her my car.
Counsel, I do want to let you know you're over your time, and I know there are some other points that you were interested in touching on. So if you have other points that you want to make sure you get a chance to briefly address, I would suggest that you might want to turn to them.
Well, Your Honor, I appreciate that, but I did file a motion for more time. It was denied. Unfortunately, I believe, I don't know if I'm the last case here, but I think I was told that. So if I could just be allowed to additional time to complete, then I think this court should grant that time. Again, this is a case of first impression. These cases predicated on nothing but a series of lies. And I can get into them and show you a series of lies.
I guess I find that a little puzzling, that sentence. I took you again to admit to one of the violations here. So I'm describing it as a case that's predicated on nothing but lies seems a little inconsistent with your admitting to one of the violations.
And what I'm admitting to, Your Honor, let's make it clear. What I'm admitting to is rather than pay for the year 2007, just that year, because the record shows I had no obligation after that to pay through the agencies. But for a period of roughly 6 to 8 months, instead of paying to the agency, I paid directly to my child's employer.
And you're also admitting, although you deny that it was a substantial failure, I thought you were admitting that you did not pay all of the amounts that you were required to pay when you were required to pay.
Yes, I admitted that. My belief was during that period, I did not make, well, yes, during that period up until 2010, so I'll go a little further. During that period, I did not make all the required payments. I don't think so. That was my belief. But after that period of time, I did, because we kept records, and we kept records in the visitation notebook. And that notebook, again, was lost, concealed, or destroyed. So that was the reality. That's what existed between her and I. The record also shows that throughout that whole period, while she claims not to have received child support, while disciplinary claims no child support was paid, the record shows that we were back and forth in court. but yet I'm talking about in Virginia concerning custody of the child, but no issue was raised by her concerning child support. We were there in 2015. We were there in, again, I believe 2013, but no issue was raised concerning child support. The fact is that in this case, this case is about revenge and recognition by disciplinary counsel to establish a precedent in this jurisdiction. But the facts show that this case is predicated on lies. First and foremost, Ms. Allen, well, and this doesn't at all mitigate from my obligation to pay child support. I made that clear in my brief. I'm obligated not only by law, but I'm obligated by God to support my child. And I consider that very seriously. But the fact is that Ms. Allen and I began a relationship. She deliberately misled me into telling me she could not become pregnant. This is in the transcript. She encouraged me to have unprotected sex with her. As a result, she became pregnant. Now, when she became pregnant, she wanted me to take care of her. I told her no, I would take care of my child, but not her. That's in the record. By email written to her in 2009, I referenced the fact that she still harbors bitterness and anger because of that fact. And let me address that to you.
I do want to encourage you if you, because we will give you a little bit more time, but not a lot more. So if you have, I know you have a set of arguments about the other violation, and I would encourage you, if you have something you'd like to have us here today at argument to touch on that topic rather than continuing on your first issue.
That topic goes to credibility, Your Honor. And then that was not the only lie. Shortly after the child was born, she filed a complaint in 2004. A few months after the child was born, made a false claim that I was going to take the child to Boston. The hearing committee found that was false. I never left the area. After that, I wrote an agreement, a parenting plan, which in that plan, I wrote the plan, and the plan states that each parent shall ensure that each parent has continuing contact, love, and affection between the child. Each parent shall encourage that to the child. Neither parent shall hit the child, curse the child, or act disrespectful in the presence of others. In provision 7, it had a provision for child support, that the father shall pay 1/2 of the child support for the expenses of the child. Ms. Allen went to the Office of Child Support a week later and told them there was no agreement concerning child support. That was a lie.
Counsel, let me be more direct, I guess, because
It's in the record, Your Honor.
Understood, but I'm just trying to help you through this argument in the sense that if you have a discrete set of things you want to say about the other rule violation, now is your time. We'll give you a couple of minutes to do that. Otherwise, so we'll hear from your opponent. So is there something you'd like to tell us about the other rule violation?
Let me move on to the 8 Rule 8.1 violation. First of all, with respect to the 3.4C violation, again, I admitted that I paid directly to her instead of to the child support agencies. So that is a violation. It's a technical violation. With respect to the Rule 8.1A violation, that I made a false statement of fact during disciplinary counsel's investigation, the question that was posed by disciplinary counsel was deemed by the hearing committee to be subject to interpretation. The board concluded that the question was awkwardly phrased, no doubt. This court instructed the parties to read a case. It was Max Crane. And Crane talks about that particular rule violation. And the most compelling part about Crane is that counsel was found in violation of these rules, but the question that was by giving a false or knowingly false statement of fact, in every question that was posed, in every case that was cited in Crane, the question that was posed was clear and unambiguous. Clear and unambiguous. Also, the respondents knew what the questions were asking for, but they deliberately avoided. In this case, the question was deemed to be ambiguous by the hearing committee and the board. I answered the question, and the question did not call for a statement of fact. It called for an agreement to an opinion. It asked whether I would agree with what they claim. And
Well, that was a factual claim, I thought.
well, the question,
So they asked, do you agree with the following assertion of fact?
Well, let's read the question. The question itself tells you how vague it is.
Well, I understand. I understand your question about it, your point about it being somewhat awkwardly worded, but I thought you were suggesting that it called for something in the nature of an opinion or something. But I thought they asked whether you agreed to whether you failed to make the court-ordered support payments, which seems to be factual in character rather than an opinion.
That wasn't the question, Your Honor. I think we have to actually read the question if we want to really
So I'm
understand
looking
the
at,
question.
yes, it's, do you agree that you have failed, however, to make court-ordered support payments? And your answer was no.
Right, okay. Again, the question, I didn't quite hear your whole statement, but you read the question,
Yeah.
correct?
Do you agree that you have failed, however, to make court-ordered support payments?
And my answer was no, meaning I do not agree. Now, that answer was accurate because what I was
Did you
presenting,
make court-ordered, did you make all of your court-ordered support
it
payments?
does not say all.
No, I'm just asking you, did you? Earlier you said
Well,
no.
yes, I did. I mean, but again, the record shows that the payments were made not monthly, but periodically because the income was not earned in that fashion. So yes, I did pay court-ordered child support payments as the question asked.
Well, I thought your legal argument was that question, I mean, questions can be ambiguously worded, but an answer to them can be false because there may be ways of construing it or uncertainties about it, but the answer is still definitely false under any of the reasonable readings. And so I don't know that it establishes as a matter of law a defense for you that the question could have been worded more clearly or had some ambiguities in it. I thought your legal argument was that this question could reasonably be read, and in fact was read by you, both those things, to be a question about have you never made a court-ordered child support payment? And you would read it that way, and you thought, well, no, I have made court-ordered support payments, and therefore my answer no. I will answer truthfully no. And the board ended up concluding that. I think that they don't believe that that's how you read it, and they don't think that's how you have to read it. In fact, they suggested that's probably not. I mean, I think they indicated that's not a reasonable reading of it. In context, no one would have thought that they were, is the number of court-ordered support payments you made exactly zero? Why would anybody need to know that question? That isn't really the topic. And what's wrong? I mean, I understand the point that there's a question about whether the board should have been making a determination about your mental state. But leaving that aside, what's wrong with the board's view that to the extent your theory is that that statement is so ambiguous that there couldn't possibly be a false answer to it, whatever your mental state was? The board's view is that's just not a reasonable reading of what is an awkwardly worded statement. It's got its problems, but it doesn't lend itself reasonably to that reading.
Well, yeah, and I'll tell you what's wrong with it. And I noted in my brief. One, the committee interpreted the question. The committee's interpretation cannot suffice for clear and convincing evidence. The question itself has to be clear and convincing. The question is not clear.
I guess I'm not quite sure I see things that abstractly. I mean, all the time, committee making recommendations, the hearing committee, the board, this court, interprets contracts and interprets statutes, and that you have to think a bit about what it means and figure out what are reasonable readings and what aren't. I'm not sure that precludes a conclusion by clear and convincing evidence about how it should, what readings are reasonable or not.
Well, yeah, those examples do not apply respectfully, simply because interpreting the contract is between the parties is different than interpreting one party's interpretation of the question. Also, the parties had the opportunity to negotiate, or at least theoretically, to come to these terms. So that interpretation of that contract is wholly different than an interpretation of this one single question. Furthermore, contract is going to be specific and hopefully unambiguous. This question is insolubly ambiguous. So there's a number of distinctions there. But if I can go on, another problem with as you asked, the interpretation by the hearing committee of the board is that it introduced new evidence into the case and at a lower standard of proof. And what it introduced was its own opinion of what the question was, as opposed to what the question actually is. I had no opportunity to confront that interpretation. I had no opportunity to challenge that interpretation whatsoever. So the introduction of that evidence,
I'm puzzled by that. I would have thought that, for one thing, I'm not sure that the interpreting what language means is evidence. I mean, that's what courts do all the time in various settings, contracts are one, statutes or others. But I thought disciplinary counsel made clear its view in the proceeding that the right way of reading that question was that it was asking, have you ever failed to make a court ordered support payment? And that to the extent you were arguing that no, it should be read to mean, have you never made a court ordered support payment? That issue was like front and center in the hearing, and you had a full opportunity to, I assume, argue, and in fact did argue in front of the hearing committee and the board about how that should be read. So the claim of sort of unfair surprise by evidence, I'm having a hard time getting my head around.
well, Your Honor, the problem I have with that analysis is, number one, the fact that disciplinary counsel tried to explain at that juncture is too late. That's 2 years after the question was asked, or 3 years, 3.5 years after the question was asked. So for disciplinary counsel to then in 2020 attempt to explain an ambiguous question after the question has been answered, that's a shade. That's more than a shade late. And also, disciplinary counsel, the committee again did an analysis based on a reasonable person standard. So they took disciplinary responsibility to present clear and convincing evidence. That's the question. The hearing committee then took that evidence, interpreted at a lesser standard of proof, thereby equally exposing both parties to the same level of probability, which should not be. The burden is on disciplinary counsel to prove by clear and convincing evidence, but the committee reduced that standard considerably to a reasonable person standard, then made an interpretation, then introduced that into evidence, then answered its own question, and then said, that's the answer I should have gave.
I think we have your argument on that. If you have another minute that you want to say something finally before you sit down, we'll give you a couple minutes in rebuttal, and then we'll hear from disciplinary counsel.
I was just trying to go further, but again, you're quite correct. I did make the arguments in my brief, and the board agreed that the hearing committee failed to recognize my state of mind in answering the question, so the board attempted to do that. But in doing so, the board involved the same erroneous analysis, the reasonable person standard, its own interpretation of the question. And I submit, Your Honor, if this court allows such evidence to be used, that opens the door for all kinds of problems. This court will endlessly be evaluating the nature of a question, an ambiguous question, to find out what it is. We're attorneys. We know how to phrase questions. We also know how to phrase them ambiguously on purpose to entrap one. So if this court accepts this type of evidence and this type of analysis, disciplinary counsel will have free rein to ask anything they want, as vaguely as they want, and with the hopes that the hearing committee would then come and save them. That's exactly what happened in this case. That's inherently unfair.
Thank you, Mr. Blackwell. We have your arguments. We'll hear from you.
Yeah, I will.
Counsel,
Is my time up?
yes, your time is up. We're here from your rebuttal.
Thank you. Yeah, I apologize. I didn't know if I had time. I didn't state whether I was serving the time.
We'll give you a couple minutes of rebuttal.
Good afternoon. Jack Metzler for the Office of Disciplinary Counsel. May it please the court. I'd like to start today with the sanction because as the arguments so far show, Mr. Blackwell does not contest that there's been a violation of Rule 3.4C. He is, as you suggest, Judge McLeese, contesting the extent of that violation. But the sanction that the board recommended in this case doesn't really depend on, it's appropriate regardless of how you resolve those challenges. Because here's what it does. The heart of the misconduct of the Rule 3.4 violation is Mr. Blackwell took it upon himself to decide whether and how he was going to comply with his child support obligations, regardless of what the court said. So the court said, pay into the Maryland Child Support Agency. And he said, well, no, I'm going to pay, I'm going to pay out of my pocket in cash or money order and other untraceable means. The recommended sanction addresses that, and it does so directly in three ways. First, it imposes a sanction or a suspension that is in line with other violations of Rule 3.4C. And as those were set out by the hearing committee and the board in cases like Askew and Murder and Lopez. But then secondly, it allows Mr. Blackwell the opportunity to address his misconduct by making up for it. That is, paying the arrears, the back child support that he failed to pay for all that time. It gives him the opportunity to do that quickly by staying most of the suspension so that he can get back to work and start to earn money in order to pay his obligation. It gives him 3 years of probationary period in which to come into compliance. And then finally, the recommended sanction imposes conditions that make sure he actually does it, that he doesn't return to taking matters into his own hand, deciding for himself whether he's going to comply or not. There is oversight and reporting to make sure that he is regularly paying. And at the end, if he comes into compliance, he has a carrot, which is not having to serve the remainder of the suspension and also a stick. If he fails to come into compliance, he will have to serve the remainder of the suspension and then will have to demonstrate that he has come into, has paid all of his obligations before he can be reinstated. So, importantly, though that sanction, all told, doesn't really depend on the extent of his violation, right? If he can show to satisfy to the Virginia authorities that he's paid substantially all of the child support, then this will actually be very easy for him to comply with. And it doesn't put it on this court to figure out exactly how much. We know that there was a violation. He admits it. He disputes the extent, but the sanction is designed to remedy the violation, whatever the extent is.
Does your point about sanction here also embrace the idea that the sanction could be upheld without regard to whether there was a violation of Rule 8.1?
I think that's correct, Your Honor. The 8.1 violation, which we think the court should adopt the hearing committee and the board's findings on the 8.1 violation, it certainly emphasizes the need for this sanction. And I think together the 3.4 violation and the 8.1 show a pattern that is consistent with how Mr. Blackwell has behaved the entire time, which is deciding for himself. And we can get into the 8.1 in a bit, but as you heard in the argument so far, he believes that he can just put his own interpretation on without telling anybody and follow that. In fact, what it was lying in response to a question from disciplinary counsel. So I think that exacerbates the seriousness of this misconduct. And I think together the violations could justify a greater sanction than what the board has recommended. But we didn't take exception to this sanction. And we think that with or without the 8.1 violation, the recommended sanction is well within the range of acceptable outcomes and comes to this court with a heavy amount of deference. But getting back to the Mr. Blackwell's arguments about the extent of the Rule 3.4 violation, I'd first just like to point out that the orders are pretty clear from at least June of 2007 until the end of 2010. So more than 3 years, nearly 3.5 years probably. He was under orders to pay support to the child support agencies, and he admits that he never did that.
Is that only in Maryland? That's before we get off to Virginia, or is that?
So yes, that's correct. So just to briefly review, the child support in this case started as a result of the custody case in Virginia. And then Virginia asked Maryland to establish the child support order, which it did. And because I think Mr. Blackwell lived in Maryland at the time. And eventually the proceedings in Maryland were concluded at the end of 2010 at the request of the party. So I'm talking now about the period between from 2007 at least until the end of 2010. The requirement was in Maryland. Now, Mr. Blackwell says, "Oh, I was making all of those payments, pretty much. I just wasn't making them to the agency." Well, the hearing committee found that that was not credible, and that is a finding of fact that comes to the board and to this court with a heavy presumption of reliability. The hearing committee pointed out that it was inconsistent with all of the other evidence, including the documentary evidence that Mr. Blackwell was able to bring, and the correspondence between the two, between him and Ms. Allen, and of course, Mr. Blackwell's own testimony, for example, in the Maryland proceeding where he said, I paid what I could. Sometimes it was $50, which is not even 10% of, and he said, I didn't pay monthly, I paid what I could, and so forth. So I think the finding that Mr. Blackwell didn't pay even close to what he was required to pay, either $550 a month or in the aggregate $6,600 a year, it is one that, the hearing committee made that finding, and I believe it is supported by substantial evidence in the record. I would like to just briefly address this notebook. Again, the hearing committee found that there was not evidence sufficient to show that that this notebook necessarily contained, any substantial information about payments. So Ms. Allen was not sure. Mr. Blackwell, says it was in there, but the hearing committee did not credit that as or make a finding with regard to that. And I don't think there is evidence in the record that would support making such a finding.
Well, if the hearing committee had credited Mr. Blackwell's testimony, then they could have found that it had information.
That's correct, but by
So there's evidence to support such a finding if one has been made. Your point is, I guess, one wasn't made.
Well, so I think you're asking whether had they made that, whether there would have been record evidence to support it. And
I was just taking your sentence, which was there wasn't evidence. In the record
I hear
to
you.
support a finding.
If the hearing committee had found that credible, then yes, that would be supported by evidence. But in fact, they made the opposite. They said his claim to have made all of the payments was not credible, and I think that's at page 41 of the hearing committee's report. And was inconsistent with his own testimony with the record evidence that disciplinary counsel and Mr. Allen and Mr. Blackwell provided. So the idea that he was prejudiced by the absence of this of the notebook or by its loss is, it just simply doesn't add up.
But I'm not quite sure. You just were recounting the finding the board, the hearing committee made on the ultimate question of whether there was, all or mostly all of the payments made. But it sounded a little murkier about whether the hearing committee made a clear finding about what was in, what would have been recorded about all of that in the notebook. Is there an express finding saying, Mr. Blackwell claims that in this notebook would be the key to everything. It would all be reported in there in a very organized way. We don't believe him. Was there a clear
There is not.
negative credibility?
There's not a negative credibility on that, but to the extent I'm adding an inference that Mr. Blackwell says he made all or nearly all or close to all of the payments. So I take the allegation to be that from beginning in 2009, those were recorded in this notebook. And I'm saying that that is directly contrary to the hearing committee's finding that
Right,
it was
Mr.
not
Blackwell's
credible.
point is
He made all of them.
if they had the notebook, they would have made a different finding. or not necessarily even that, because they would have made a different finding, at least as during for the period where the notebook was recording transactions, which was not the whole time period.
Well,
So it's a little circular. I mean,
there is also, there's also a finding that.
unless they expressly say, we don't believe what he's saying with the notebook, it doesn't really fully answer his prejudice argument. To say, well, he's, saying there's information in a notebook, we're going to rule adversely to him. We don't know what was in the notebook, but we know what the rest of the evidence is. That's not really quite a clear and full answer to the prejudice argument in the way that an adverse credibility finding, which is he's claiming there's a document that's lost that would have helped him. We don't believe it would have helped him. It's unfortunate it was lost, but we concluded he wasn't prejudiced because there's just nothing in there that would have helped him. That would have been a more direct handling of the prejudice issue, and they didn't, as I understand it, handle it that way.
Well, what they said is that they were not convinced that the notebook recorded all of these, that the notebook necessarily contained substantial amounts of information about the payments that were recorded. Or the payments that were made. Nothing required that the notebook to contain payment information. Ms. Allen said maybe sometimes it might have said that. And to the extent that there was evidence in the form of Mr. Blackwell's testimony that it did contain all of those payments, the hearing committee didn't believe it, or certainly didn't credit it. And to the extent that taken together, his argument today is that he made substantially, he paid all or almost all of what, within $2,000 of what he owed. I think the direct credibility finding that the hearing committee made was, that Mr. Blackwell was not credible when he made that. And in fact, it made a finding that was the opposite. It said he didn't pay anywhere close to $550 a month or $6,600 a year. So my time is getting short, so I'll talk a little bit about the 8.1 violation. The argument so far, I think, has hit exactly the right points. The hearing committee found that Mr. Blackwell knew he was being asked about the status of his child support payments. And the hearing committee found that he dissembled, that is, he lied in his response. The board.
I'm sorry, lie. I don't think, did they use
said
either the word dissemble or the word lie?
They used the word dissemble. It's at page 45 to 46 of the hearing committee.
And what did they say about whether his statement was knowingly false?
So at the end of that same paragraph, they concluded that he made a knowingly negative statement, which of course, I don't know if that was a drafting error or, but of course, that's just a truism saying that he knew he was saying no, which really isn't much of a conclusion. So the board focused on that and said, well, because there's not a direct finding about knowingly, we're going to engage in our own analysis. And I take it the court's order was, you're interested in our view of whether that complied with the Crane decision. And I think it did under Crane. That is a finding of ultimate fact because it has a legal consequence. The finding that he knowingly gave a false answer directly means that he violated Rule 8.1. And under Crane, that is a finding that is de novo, except to the extent that it is contrary to subsidiary findings or especially credibility findings made by the hearing committee, which need to be accepted unless they are contrary to law or devoid of evidence in the record. So in this case, so I think,
make sure I understand on your theory, if under Crane, if let's say the hearing committee just said we're not going to make a decision one way or another about whether what the state of mind was at the time of this answer, it was false. And this, here's what the question reasonably read was asking for. And we conclude the statement was false. So whether it was no or not, we just take no view. We're not going to make a finding. We have no conclusion about whether it was knowingly false. Your view is, so there's no credibility determination from the hearing committee about the respondent's state of mind. Your view is that the board, consistent with Crane, could say, well, that state of mind question, was it knowing or not, is an ultimate question. It has legal consequences. We have no credibility finding that is adverse one way or favorable or adverse. So we're not going behind anything that the hearing committee found. And although, obviously we haven't had the witness in front of us and, we're not situated well to make factual findings in the first instance in the way that fact finders normally would, we're just go ahead and make that finding ourselves in the first instance. Let's say the respondent had said, I didn't know, this is how I interpreted it. And the board could say, we don't credit that testimony. And that all would be fine under frame as you read it.
So I think that in your hypothetical, I take it, the case comes to the board without this fact finding, which is necessary to decide, the violation. Am I?
Yes.
So I think the board has a responsibility, not just the obligation, or excuse me, not just the ability, but the obligation to answer that question. And you find that in the in Rule 11, which forget which section, but the one that talks about the board's responsibilities, say that they shall make their findings and recommendations to this court as regard to the violation and the recommended sanction. So yes, absolutely. I think the court or the board not only can, but indeed has a responsibility to make that finding.
That's now, that seems kind of an odd way to get facts decided.
Say again?
Would you agree that's an odd way for facts to get decided? I mean, there are definitely rules that allow the board to take supplemental information to make factual findings. I don't really know too much about the process the board uses to do that, and whether if it turns on credibility, they just do it on the cold record, or whether they send a matter back to hearing committees to make credibility determinations when they're needed to be made in the first instance. But it sounds like you're saying you think that the board has not only the ability, but sometimes a duty to itself make credibility determinations when no credibility determination was made by a fact finder that actually had live testimony. That would just be the board's, not only its ability, but its duty. That's your position.
So I'm not suggesting that the board necessarily has to make a credibility finding. What I'm suggesting is that the court has a responsibility to make the findings that are necessary to decide whether a violation occurred. And
are you saying the board has that duty itself without the ability to consult the hearing committee and try to get the assistance of the hearing committee in making factual findings in the way that factual findings are normally made?
I'm not sure I understood that question.
Well, I mean, imagine a hearing committee heard a whole bunch of evidence and said, you know what, we're not making any factual findings. We're just, finding some violations, and we're just going to write, we don't make any credibility determinations. So they sort of abdicate what they're doing. You're saying what the board should do is on a cold record, go ahead and make all the credibility determinations as though it was the hearing committee.
I'm not sure I would go that far. That would make a very difficult case, I think, for the board to decide. And I honestly haven't thought about that. I'm not sure what the.
Well, I'm just wondering again. But your view is the board takes the view that sometimes where a legal question of ultimate fact like knowledge turns on a credibility determination, that the board on a cold record with no ruling from the hearing committee, finding from the hearing committee, can make its own, not only can, but sometimes must, without the assistance of the hearing committee, make its own credibility determination.
Well, let me answer it this way. I think what Crame suggests is that something like a state of mind determination is a question of ultimate fact that comes to the board with a de novo review. And in that posture, the board is constrained. It can't just say it's de novo, but it's only de novo in a sense. The board just can't say, you found him credible, we think he's not credible. And I think that's Crane makes that point directly. But what the board can do is make a determination on that issue, for example, state of mind, based on the record, that so long as it isn't inconsistent with the credibility findings that the hearing committee made. And you can see this in Crane itself. So in one of the violations, Mr. Crane, I may get the details exactly wrong, but in one of the violations, Mr. Crane said essentially, he suggested that he didn't have records to show what his hourly work on a probate matter. And what he really wanted was to be paid as a percentage of the probate estate. And the court was sort of fooled by that. And so it found that the finding was that was false, and that his state of mind was that he could his state of mind was intentionally false. I think the last violation in the Crane case was that it had to do with whether Mr. Crane really believed it when he told the court something or other, and I don't remember what it was. And on that one, the hearing committee said, "Oh, we believe that he really believed that," and the board said, "No, we think that was actually a lie." And this court reversed on that and said, "You can't go against that credibility finding." But in the previous one, where the hearing committee had also found no violation, the court found it was acceptable for the board to make the determination on the state of mind based on the record. So yes, that's I think, and here we're not talking about making a credibility. The board didn't say Mr. Blackwell lied. I'm sorry, that he lied in his testimony to the hearing committee. What they said is, based on the evidence, it shows that he knew what he was being asked, and he knew that the answer he gave was false. Now, this is not the kind of credibility what the court talks about in Crane is.
Why is it not? I mean, remind me, I don't have a perfect recollection of this at all, but I thought the gist of the testimony at the hearing was that the respondent, in fact, subjectively interpreted the question the way he's claiming it should be interpreted, which was to ask, have you never paid any child support payments? So when the board says, we find he knew what he was being asked and knowingly gave an answer that was untrue, it seems like whether they are saying that explicitly or not, they are not crediting his contrary testimony.
Well, I think that's correct, but the two are different, right? I think there's a difference between saying that someone's testimony was not credible, and Crane talks about this when if it's not based on demeanor or their actual observations in court, then a credibility determination is not necessarily due the same kind of deference that it would otherwise be. For the reason that credibility determinations are given that power. It's the hearing committee who can observe the person testifying and can say, yeah, it looked to me like he was lying, or I think I believe him. What the board can do though is look at the evidence in the record and say not that he was lying, because that's actually a separate violation, right? He's not. It turns out that they didn't believe that testimony, but not because they observed him and thought, we just don't believe this guy, but because it's of the actual findings that the hearing committee did make and the record evidence. I think it actually parallels Crane very well, where that's what the board did when it came to a contrary conclusion on Mr. Crane's state of mind, and as this court carefully explained, was correct to do. So to put that all together, as I said before, the hearing committee did make the finding that he knew what he was talking about, or what the question was being asked. And the hearing committee also said that he dissembled in his response. So it is, in this case, at least, it is not much of a jump to then conclude that he knowingly made a false statement of fact when he denied when he denied having when he denied the question. I'm not going to try and put it in the double or triple negative. But returning to where I started, the 8.1 violation certainly underscores the misconduct in this case. It makes it more serious. But for the reasons I started with, it doesn't really change what the recommended sanction should be. That sanction addresses the seriousness. It gives Mr. Mr. Blackwell the opportunity to correct his failure to pay child support for so many years. It gives him the time to do it, and it imposes conditions that will make sure he doesn't return to his same conduct of taking the taking court orders as suggestions by giving an incentive to pay it off and a consequence if he fails to do so.
Does my colleagues have further questions?
Okay,
Thank you, counsel.
thank you.
We'll hear now from Mr. Blackwell. We'll give you a couple minutes.
Your Honor, first of all, counsel makes a statement that this case involves me taking matters in my own hand. The hearing committee found to the contrary. The hearing committee found that there were compelling mitigating circumstances for the events that occurred. The hearing committee found that the reason why payments were made in that manner was because I did not earn income monthly. That's not taking matters into your own hand.
Counsel, I thought that you expressly disavowed in the disciplinary process any defense of inability to pay, but it sounds like you're now suggesting something in the nature of an inability to
I'm sorry.
pay.
Could you-
I'm sorry. Yeah, I apologize. That sounds like you're suggesting you had a defense of inability to pay or comply with the order. And I thought you expressly disavowed at the hearing committee stage, presenting any kind of a defense about inability to pay.
Your Honor, I beg to differ. Inability to pay, I was precluded from raising that as an issue, first of all. Not that I decided not to raise it, I was precluded. Secondly, the facts of the case is what must be focused on, Your Honor. The hearing committee found, and these are not, you can call it inability to pay, but the hearing committee found that I did not earn income monthly. The hearing committee found that I earned income periodically. The hearing committee found that I made payments directly to Ms. Allen when I had the income. So if that equals to, that's a legal concept, inability to pay, but let's look at the reality and let's look at the findings that were made. So those findings were not made by me. They were made by the hearing committee. So that closes the door to whether or not I took matters into my own hands. Also, the hearing committee found that during that period of time, the only way I could see my child was to concede to Ms. Allen's demand that I gave her the money directly. The hearing committee found that. And so that's exactly what I did. So this matter about imposing a greater sanction to teach me a lesson, not to take matters into my own hand. That's like sanctioning a person with no legs because they can't walk. So I don't know what that means. He also talks about the fact that from 2000 to 2010, there was non-compliance. But if you look at, again, the record, you'll see that the order that was issued in December of 2007, it directed that payments be made to Ms. Allen. The order that was issued in 2010, it affirmatively closed the case and stated that payments should be made directly to Ms. Allen, and it said it should no longer be paid, should not be paid to any child support agencies, plural. So that's clear. So disciplinary counsel somehow wants to interject Virginia Child Support Office having jurisdiction. I should have paid to them, but it conceded they didn't have authority to make me do so because they didn't follow the law. The hearing committee and the disciplinary counsel wants to say I should get a greater sanction because I'm hiding behind technical arguments. Technical arguments, they didn't follow the law, so therefore I had no obligation, and I should get a greater punishment because of that? I think not. The disciplinary counsel also said something about making $50 payment. There's nothing in the record about that. Disciplinary counsel mentioned that I went to the court in 2009 and told them I was paying directly to Ms. Allen. Yes, because the 2007 order said that I could. So I told the court that, although it was not in the amounts because I did not earn income monthly. The disciplinary counsel talks about the fact that the board making a credibility finding. That's exactly what they did. That's exactly what the board did, made a credibility finding, and it was against the finding by the hearing committee, who is in a better position to make such a credibility finding. If they made the finding, and again, the finding based by both bodies that my interpretation was false, that was never made. That was never stated. What was stated was that they had a preference based on a reasonable person standard, that their interpretation of the question is what should prevail. That's inherently unfair. So, and such a determination, again, is contrary to the rule of law. He talks about Crane. Again, the fundamental focus in Crane has to be, it is the violation, but the violation stemmed from an unambiguous and clear statement. The court notified Crane that rather than an hourly basis, it would be on a percentage basis. Clear. Crane knew this, but Crane, he didn't want to abide by that. So he still wanted to submit his billing on a percentage basis. And when he was asked to provide information of the hourly work that he did, he said he did not. Clear question, clear false answer, because the hearing committee found out that he did have these records. Question clear, question unambiguous.
Thank you, counsel.
And he knew what they asked.
You're over your time. If you want to wrap up in a sentence or two, that's fine.
All right,
but,
I wouldn't know. And I'll wrap up. Again, I urge this court to clearly and carefully examine the record. I don't need to defend myself in this matter. I'll let this out. The person who started this by lying, the person who lied throughout. Let's look at her words. Today is June 16th, exactly a month since our first date. What a magical night. That I was a little nervous at first, but probably more and more relaxed and find myself around you. I have been thanking God for letting you cross my path on the night of May 10th. When we first met, you have been a blessing from the sky, the picture of a perfect and ideal man that had kept hiding inside me for years. I was not ready for him until now. I have looked for love in all the wrong places. However, the Lord has kept me the best for last. Now I'm ready for true love. She goes on to talk about how she's mesmerized by my mind, my wisdom, my belief, and my sense of fairness and discipline. I know that you stimulate my mind. She goes on and she says, finally, Kenny, I hope to continue to grow together in this journey and complement each other's existence. I am looking for happiness, and I know that God blessed me with you. When there is no longer confusion in my life, Kenny, I love you forever and all that you bring out in me. That is what started this case. That speaks to my character. The next thing that happened after that was her telling me she could not become pregnant and insisting that I had.
I think we've
But
heard your
again,
counsel.
Yes, Sean.
I think we've heard your
I'm not
argument.
going to dwell on that again.
I'm sorry.
I'm not going to repeat that again.
Thank you.
But-
We've heard your argument. We appreciate the arguments and the briefs of both parties, both today and in their filings, and the case is now submitted, and we will stand in recess.
All rise. This honorable court is now adjourned